Okay, Chalmers.
Your Honor, we have the ability to share our roster with you if you would like.
Would that help the scoring panelists?
Yes.
All right, Chalmers, if you would do that, please.
Yes, Your Honor.
And while Chalmers is doing that, I'll let you know that I know that Zoom has the capacity in most cases to record Zoom calls. Is anyone planning on recording this? And if you are, have you passed that by the other side? Emma?
Your Honor, we do not plan to record this Zoom call today.
Okay, Chalmers?
And that for us too, Your Honor.
All right, thank you. Once we get going, I don't know if you folks have participated in these before, but once we get going, we're going to go straight through with no recesses or breaks, unless there is some kind of medical emergency or something untoward like that, but we'll go from the beginning to the end without any pause. I'm going to ask the scoring panelists now whether you see any reason to believe that there is a conflict of interest, some kind of bias with you and the people you see on your screens.
None for me, Your Honor.
Okay, Aaron, Nick?
None for me, Judge.
Brenda?
None for me.
All right, good. Thank you. As you have probably been previously, that for the teams and the coaches, that any disputes arising out of this competition must be reported in accordance with the competition rules. Do we have timekeepers for each team?
Yes, Your Honor.
And who are they?
Your Honor, Saffron will be timekeeping for the prosecution today.
Okay, and Feliciana, you are going to be the timekeeper for the defense, is that correct?
Yes, Your Honor.
All right, and I'm sorry, I didn't hear who was doing it for the prosecution. Emma?
Saffron will be timekeeping.
Okay, Saffron, I see you there. All right, I'd ask each of the timekeepers periodically to hold up where they are along the way so that everybody will have an idea of how much time is being consumed. I will be enforcing the time deadlines scrupulously, and that may affect your scores if you run over. So please try to keep that in mind as you're making your presentations. At this time, I would like Emma and Chalmers to introduce the members of your teams. Emma, why don't you go first?
Good afternoon, Your Honor, members of the jury and opposing counsel. My name is Emma Senishin. My co-counsel and I represent the prosecution in today's case. Co-counsel, if you could go ahead and introduce yourselves.
Good afternoon. My name is Alexandra May.
Good afternoon. My name is Lily Humber.
I'm sorry, Lily, would you identify yourself again?
I'm Lily Humber.
Oh, there you are. Okay.
May our witnesses introduce themselves?
Yes, they may.
Good afternoon. My name is Carolyn Johnson, and I am Kyle Kuzak.
Good afternoon, Your Honor. My name is Tess Hayden, and I am Jordan Markowitz.
Good afternoon, Your Honor. My name is Lola Fakes, and I am Alex C. Fuentes.
All right. Team G. I'm sorry, that was Team G. Team M.
Good afternoon, Your Honor, counsel, members of the jury. My name is Chalmers Powell, and I will be representing the defendant, Avery Becker, in this case. May my co-counsel now introduce themselves?
Yes, they may.
Good afternoon, Your Honor, counsel, members of the jury. My name is Madeline Proctor, and I will be representing the defendant, Avery Becker, in today's case.
Good afternoon, Your Honor, counsel, members of the jury. My name is Ashlyn Bierick, and I will be representing the defendant, Avery Becker, in today's case.
Your Honor, may our witnesses now introduce themselves?
Yes, they may.
Good afternoon, Your Honor, counsel, members of the jury. My name is Trenton Schultz, and I am Taylor Perkins.
Good afternoon, Your Honor, counsel, members of the jury. My name is Jordan Merriweather, and I am Blake Van Owen.
Good afternoon, Your Honor, counsel, members of the jury. My name is Juliette Bruner, and I am Avery Becker.
Okay, thank you. At this time, I'm going to swear in the team members and the scoring panelists and the witnesses. I won't ask you to stand, but I will ask you to raise your right hands, please. We do this in an effort to maintain a level of professionalism and to uphold the code of ethical conduct during and after the mock trial proceedings. Team members, please raise your right hands. Team members, do you promise that the presentation you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition? I see you all nodding and you're all mute. I'm not sure that works, but that's okay. Witnesses, would you raise your right hands, please? Do you promise that the testimony you are about to give will faithfully and truthfully conform to your witness statements, that you will not add material facts or opinions which are not contained in the case problem, and that you will follow the rules and procedures of the mock trial competition?
Yes, Your Honor.
Thank you. We have no gallery members, so they forego the pleasure. Scoring panelists, will you please raise your right hands? Do you promise to adjudicate the mock trial competition as fairly and objectively as possible in accordance with the facts, procedures, and rules of the mock trial competition?
I do.
Yes, Your Honor.
Thank you. With that, excuse me, I expect we are ready to go. Is there any preliminary matter that either team wants to bring before the court?
Yes, Your Honor. We have 4 housekeeping matters at this time.
Go ahead.
First, Your Honor, we request permission to reserve any time not used in our closing argument for rebuttal.
Is there any objection to that?
No objection, Your Honor.
All right, that motion is granted.
Your Honor, there are stipulated facts that have been agreed to before the trial today. We request that those facts are constructively read into the record.
Is there any objection to that from the defense?
No objection, Your Honor.
And they shall be constructively read into the record. And do the scoring panelists each have a copy of the stipulated facts?
Yes.
Okay, good. Emma?
Your Honor, when we enter exhibits during the trial today, we intend to screen share the exhibit at the onset of the questioning of the witness. We would then proceed with entering the exhibit. In this case, the jury would not constructively see the exhibit until Your Honor has formally admitted it. Would this be acceptable, Your Honor?
Chalmers, what do you think of that?
Your Honor, Team M's plan was to request while entering exhibits, we may ask witness and the counsel to refer to their case material, and then if it is admitted, may we request it be screenshot to the jury.
Ms. Senishin, what do you think?
Your Honor, while we had planned to screen share the exhibit before it has been admitted so that the witness and all scoring panelists are able to see the exhibit we are trying to enter, we will coordinate with what the other team would like to do in this case.
All right, very good. So my understanding is that the plan going forward is for the lawyer asking questions and the witness responding to the questions will have a chance to look at the exhibits, proposed exhibits in their materials. Then there will be a decision as to its admissibility, and if it is admissible, then it will be shared with the scoring panelists. Is that an adequate summary?
Yes, Your Honor.
Yes, Your Honor. So to confirm, you would like the exhibits to be screen shared after they are formally admitted by Your Honor.
Yes, that's how we'll go forward.
Thank you, Your Honor.
And there's
Finally,
one more.
yes. Would it be acceptable to Your Honor if time is paused while screen sharing those exhibits should any technical difficulties arise?
Yeah, I think we're going, and I'm sorry, Mr. Powell, I didn't give you a chance to respond, but I have thought about this a little bit. So I think what we're going to do is not pause time as you go forward and try to screen share. But if there is some issue that arises with it not coming up, then we're going to ask the timekeepers to pause the time until that issue is resolved or not. Is that okay?
Yes, Your Honor.
Mr.
We have
Powell?
no further.
Yes, Your Honor, that's perfectly.
Okay. And
And
Ms.
we have no further housekeeping matters at this
Okay,
time. Sorry.
Powell, is there anything else from the defense?
Your Honor, with those privileges granted to the defense, we are ready to proceed.
Okay. Scoring panels, are you ready to go? All right. Prosecution, you're opening.
Permission to proceed, Your Honor?
Go ahead.
Mischief was intended, in murder it ended. Good afternoon, Your Honor, members of the jury and opposing counsel. My name is Alexandra May, and my co-counsel and I represent the people of Colorado. We are here today to provide a story, the story of March 6th, 2020, the day that Mr. Mackenzie Brackman's life was taken far too soon. Mr. Brackman was a mock trial coach at Colorado High School, volunteering his time to provide coaching to a group of kids in order to allow their love for mock trial to continue to grow. Now, let me tell you a story, the story of Avery Becker. It's 3 o'clock on a Thursday. Miss Becker has just gotten home from school. In a fury, she throws down her backpack and storms into the kitchen. You see, after practicing for countless hours for mock trial and getting winning results in competitions, her coach, Mr. Brackman, has continued to belittle her efforts. Their fighting has escalated, and there's an unprecedented amount of tension between the two of them. You see, Mr. Brackman demoted Avery from the A team and she boiled and raged. And after that, she climbed on the hood of his car and wrote in permanent marker, "Worst Attorney Award." As she hides the Sharpie away, she texts her friend Alex, presenting her ideas to break into Mr. Brackman's house and vandalize his belongings. Her eyes tearful with anger, Avery's mom enters the kitchen and asks what's wrong, to which the defendant replies, "I will get back at him if it is the last thing I do." The defense will call 3 witnesses to the stand today. They will call Mr. Taylor Perkins to the stand, Avery's lifetime best friend and only alibi for that day. Mr. Perkins is so loyal to the defendant that he dropped out of mock trial in order to benefit the defendant. What else would he be willing to do for her? They will also call Mr. Van Owen to the stand, an expert testifying in this case today, testifying in a field of a job that he quit. And last, they will call the defendant herself to the stand, Miss Avery Brackman, who's had many previous problems with Mr. Brackman, including writing on the surface of his car in Sharpie. Miss Becker was not at school the day of the murder. And in the end, she went to the house to vandalize it, but in the end, Mr. Brackman's life was taken. The mischief was intended, but murder was the way it ended. The prosecution will also call 3 witnesses to the stand today. We will call Miss Kyle Kuzak to the stand, an expert in crime scene reconstruction, who conducted a meticulous investigation, and after conducting this investigation, has conducted a timeline based on the evidence found that demonstrated a perpetrator broke into the house and then stabbed Mr. Brackman with a knife. The prosecution will also call Detective Jordan Markowitz to the stand, an expert in data tower cell analysis, who obtained the cell tower records in this case and was able to place the defendant's phone pinging off a cell tower in range from Mr. Brackman's house the day of the murder. And last, we will call Ms. Alex Cifuentes to the stand, a friend and teammate of the mock trial team to the defendant. Ms. Cifuentes will testify to receiving messages that express the defendant's intent to break in and vandalize Mr. Brackman's house. Your Honor, members of the jury, the prosecution holds the entire burden of proof in the case today, but you will see that we have met that burden of proof, and you will see that we have provided sufficient evidence for the defendant to be found guilty of burglary of a dwelling in the 2nd degree and 1st-degree murder. At the end of the trial here today, my co-counsel, Ms. Lillian Humber, will summarize the facts presented to you, and you will see that we have proved beyond a reasonable doubt that the defendant is guilty. As the trial goes on today, I ask you to keep a simple phrase in mind. Mischief was intended, in murder it ended. Thank you.
All right, Ms. May, thank you. When I said there would be no breaks in the trial, I think I should have also told you that there will be a pause between each segment of the trial so that the scoring panelists will have an opportunity to mark their score sheets. So when you do that, and I guess we'll do that after the second opening, please give me, scoring panelists, please give me some sign that you were done, okay? All right, Team M, you have your opening.
Yes, Your Honor.
Go ahead.
Justice doesn't come in a puzzle box with a picture on top. It's Friday, March 6th. Detective Brackman is called to the home of Mackenzie Brackman. Mr. Brackman is dead on the floor, and there's a bloody knife nearby. She continues to investigate, but she does not have any DNA. She does not have any fingerprints. She does not have any suspects. Looking for one, the detective calls a single member of the mock trial team, Miss Alex Cifuentes, who immediately points the finger at Avery Becker, and the detective zeroes in. This is his chance to put that picture on the puzzle box. In an effort to make all the pieces fit Avery Becker, the detective misses key pieces along the way. The scheming witness, the alibi, and the stronger suspect. Avery Becker was a senior at Colorado High School. She was the star of the mock trial team. Alex Cifuentes and Mr. Brackman often asked her to work harder. Talented though she may be, she isn't perfect. When Mr. Brackman told her she didn't deserve any of the awards she won at the regional tournament, she let her emotion get the best of her. She took a Sharpie to Coach Brackman's car. Kicked off the team for good, she went home and licked her wounds while trying to make amends. But she did not put on a mask and break into Mr. Brackman's home. And she did not stab him in the back. Good afternoon, Your Honor, counsel, members of the jury. My name is Ashlyn Bierek, and together with Chalmers Powell and Madeline Proctor, We have the privilege of representing Miss Avery Becker today. The prosecution must prove to you each and every element of each and every crime. They will fail you. As they do, pay attention to three things: screenshots, cell tower records, and stronger suspect. Screenshots. Detective Markowitz let Alex Cifuentes send her screenshots of text messages she claims came from Avery Becker. Though the detective claims to be an expert in cell phone data recovery, she didn't recover any data. She didn't confirm that Avery Becker sent these text messages, and she did not question that Miss Cifuentes forgot her phone on the day of the interview. Can the prosecution really prove that Avery Becker sent these text messages? Cell tower records. These records are just dangerous enough to point the finger at Avery Becker, but too vague to do much else. They won't tell you where Avery Becker was on the day of the murder. She was with Taylor Perkins all day. They will not tell you if she had her phone that day. She didn't. Alex Cifuentes was the last one with her phone. And they won't rule out any alternate suspect whom Detective Markowitz failed to investigate. Ask yourselves, what do these records really prove? Stronger suspect. A fellow student at Colorado High School, Blair Rollins. Blair's father was convicted of murder and sentenced to life in prison. His attorney was Mackenzie Brackman. Blair Rollins only lived a few blocks away from Avery Becker, and Blair Rollins was never interviewed for this case. Why did no one question Rollins? At the end of this trial, Ms. Madeline Proctor will walk you through the minefield of reasonable doubt. The ignored screenshots, the ignored alibi, and the ignored alternate suspect. She will ask you for a verdict of not guilty because justice doesn't come in a puzzle box with a picture on top. Thank you.
Ms. Varick, thank you. We'll take the pause while the scoring judges fill out their score sheets. And Brenda, I can't see you if you are done.
I'm done.
All right, thank you. Prosecution, you may call your first witness.
Your Honor, the prosecution would like to call Ms. Kyle Cusack to the stand at this time.
Ms. Cusack, I'll remind you that you remain under oath as you took at the beginning of this proceeding. Ms.
Yes,
Mago.
Your Honor.
Thank you, Your Honor. Good afternoon. Could you please state your name and spell your last for the record?
Kyle Cusack, K-U-Z-A-K.
Ms. Cusack, what do you do for a living?
I am a Colorado Bureau of Investigation certified crime reconstructor, or a CSR.
How long have you been doing this?
19 years.
And what does this job entail?
Well, I investigate all sorts of complex crimes, including burglaries, home invasions, and other property crimes, fatal accidents, and armed robberies.
Who do you work for, Ms. Cusack?
I work for the city of Denver, and I have for the past 3 years.
Construction pursuant to Rule 702.
Mr. Powell?
No objection, Your Honor.
All right, then. Ms. Cusack is admitted as an expert witness in the field of crime scene reconstruction. Go ahead.
Thank you, Your Honor. Ms. Cusack, what is your involvement in the case here today?
I was called to visit the scene of the homicide at 444 South Flower Street.
Whose house is this?
Mackenzie Brackman's.
Were you able to identify the victim as Mr. Mackenzie Brackman?
Yes.
Other than visiting the crime scene, did you do any other work for the case?
Yes, I also reviewed all the police reports in this case, as well as the evidence, the 4 ring security camera videos, and the autopsy.
With your experienced background in this field, how do you go about conducting your investigations?
Yeah, so I first assume that every case is going to trial, so I conduct a thorough investigation accordingly. And then second, starting from day one, I memorialize, document, and organize all of my evidence with a mindset of future reconstruction.
What is the benefit of conducting your work this way?
Well, this ensures that I have an accurate and efficient flow of my CSR work, which I then approach in a 5-step process.
What is that 5-step process?
Recognition and documentation, collection of evidence, evaluation of evidence, testing and hypothesis, and reconstruction.
Did you go through each of those 5 steps for this case?
Yes.
After gathering all of your evidence from the case, what conclusion did the evidence lead you to?
Well, the ring security camera videos exhibit a perpetrator matching the exact height and build of the defendant approaching the residence and breaking in.
Your Honor, I am now asking the witness to view what has been previously marked as Exhibit 12. Ms. Kuzak, do you have Exhibit 12 ready to view?
Yes.
Have you viewed Exhibit 12?
Yes.
Ms. Kuzak, what is Exhibit 12?
Exhibit 12 is a video of the intruder unlawfully entering Mackenzie Brackman's house.
How do you know this?
This is the video that I reviewed in my investigation.
Is it a fair and accurate representation?
Yes.
Your Honor, I now move to enter Exhibit 12 into evidence.
Mr. Powell,
No objection to 12, Your Honor.
you say no objection?
Yes, Your Honor.
And Exhibit 12 is entered into evidence.
Permission to ask my co-counsel to share her screen with Exhibit 12 on it.
Granted.
Ms. Kuzak, what conclusion did this video lead you to about the perpetrator?
Well, this video is critical to the case as it shows the build of the perpetrator, which matches the exact general height and build of the defendant, Avery Becker. It also shows that the perpetrator is wearing gloves, which is why no DNA evidence was recovered except for Brackman's from the scene.
Thank you, co-counsel. You can stop screen sharing now. Ms. Kuzak, you stated that along with the videos you analyzed, you also analyzed photographs. What did these photographs show?
Yeah, so I also reviewed photographs that showed scuff marks on the kitchen floor near the back door, an open drawer with several small knives in it, and a knife block with an open slot for a large chef's knife missing from it. And the knife ultimately recovered from the crime scene was a knife that would fit perfectly into this slot.
Did the photographs provide any insight into your investigation?
Yes, the floor scuffing indicated that there was close contact between at least 2 individuals.
Ms. Kuzak, did you review the autopsy report in this case?
Yes.
What did it tell you?
It establishes that the victim was stabbed only 1 time in the upper back shoulder area.
Ms. Kuzak, you previously mentioned that making timelines are a very important part of your reconstruction process. Did you create a timeline that allowed you to come to a conclusion of the events of this day?
I did, yes.
Can you review this timeline for us?
Yeah, so first the victim must have been alerted by the ring security system of the intruder approaching the residence. And then he likely looked for a defense weapon in the drawer with many knives in it, but then approached the knife block on the counter to reach for the larger chef's knife to introduce into the encounter.
Based on this timeline, what did you conclude happened when the victim confronted the intruder?
Well, the 2 individuals struggled over the knife in the kitchen, knocking over the plate and breaking it. And then at some point, the intruder disarmed the victim and obtained that knife.
And according to the timeline, once the intruder obtained the knife, what happened?
Well, based on the location and position of the stab wound, the intruder must have reached over the victim and stabbed him in the upper back shoulder area from a bear hug position.
Ms. Kuzak, are you aware that there are other expert witnesses working this case?
Yes, I'm aware that Blake Van Owen is working this case for the defense.
Did you review Mr. Van Owen's theories of this case?
I did.
Do you agree with his theories?
No.
Why do you not agree with them?
Well, Blake Van Owen regrets to include significant critical evidence in this case, such as the knife block, the open knife drawer, the broken plate, and the scuff marks. And on top of that, Blake suggests that Brackman was surprised by the intruder, which is just ridiculous.
Why is it ridiculous that Mr. Brackman was surprised by the intruder?
Well, not only did Brackman own Ring doorbells, which sole purpose is to notify homeowners of movement near the house, but also Brackman would have been notified by the intruder opening the door and walking through the kitchen.
Was your investigation in this case thorough?
Yes.
Do you feel you have significant evidence to come to a conclusion?
Yes.
Ms. Kuzak, based on your expert opinion and extensive background in the field of crime scene reconstruction, what is your conclusion of this case?
In the end of the day, this was clearly a planned burglary gone bad. The intruder had knowledge of the victim's property and likely chose a time of day that would have placed the victim outside of the home. However, the victim was indeed present and alerted to the intruder's presence before the intruder entered the home, in which he grabbed a defense weapon, but unfortunately, in the ensuing struggle, he lost this defense weapon and was murdered.
Thank you, Your Honor. No further questions at this time.
Thank you. Mr. Powell, you have cross-examination.
Yes, Your Honor. Good afternoon, Ms. Kuzak. My name's Chalmers Powell. Let's talk about your conclusions. The physical evidence at the scene leads you to only one conclusion.
Mr. Powell, you need to come closer to your microphone.
My apologies. Did you hear my question, Ms. Kuzak?
I did not. Can you please repeat that?
Ms. Kuzak, the physical evidence at the scene only leads you to one conclusion, right?
Yes, that's how I conduct every case.
Mr. Brackman was alerted to the intruder.
Yes.
And then likely looked for a defensive weapon in the knife drawer.
Yes, that is my conclusion.
You have Exhibit 7 in front of you.
Yes.
Exhibit 7 is a picture of the knife drawer, correct?
Yes, it is.
That's a fair and accurate copy. That's a fair and accurate depiction of the knife drawer, correct?
Yes.
Your Honor, the defense requests that Exhibit 7 be admitted to evidence for its accuracy and authenticity have been shown.
Does the prosecution have an objection?
Your Honor, I may ask that the defense lay a little more foundation as to what Exhibit 7 will be used for, so I am objecting to relevance or for the defense to lay further foundation.
Mr. Powell?
Your Honor, sufficient foundation has been laid that the Exhibit 7 is a photo of a knife drawer. I don't need to lay foundation for what I'm using it for.
Ms. May?
I am simply asking because this was not brought up on direct, and I would like to change my objection to relevance.
Or why is this irrelevant?
I do not see what this is being used for to object to Ms. Kuzak on, or to cross Ms. Kuzak on.
Yes, you may, Mr. Powell.
Firstly, Your Honor, my cross-examination is not bounded to Ms. May's direct examination. Furthermore, this is relevant because it shows that Mr. Brackman looked into this knife drawer, decided to not choose all the knives in the knife drawer, and made the unlikely choice of choosing the knife from the knife block. It goes to Ms. Beck's credibility, Your Honor.
I'm going to overrule the objection and allow you to go forward, Mr. Powell.
Your Honor, permission for my co-counsel to publish Exhibit 7 to the jury.
Granted.
So, Ms. Kuzak, Mr. Brackman looked into this knife drawer,
Yes, that is my conclusion.
looked at all these knives,
Yes.
but then chose a knife from the knife block.
Yes, assuming that he wanted a bigger knife to introduce in the encounter. Yes.
Those knives look pretty big, don't they?
We do not know the actual size of those knives, so I would not say that, no.
You were at the scene, weren't you?
Yes, I was.
You saw these knives,
Yes, I did.
and these knives are fairly big.
That is not in my affidavit. Would you like me to respond?
No, that's okay. Ms. Kuzak, then after taking the knife from the knife block, Mr. Brackman confronted the intruder with the knife.
Yes.
Thank you, Ms. Vierik. Ms. Kuzak, so it's your opinion that Mr. Brackman got an alert from the Ring video, went to the kitchen, looked in the knife drawer, saw all of those knives, didn't pick that knife, went over here, picked up another knife, instead of just calling 911 and locking the back door.
Yes, because the intruder was entering into his residence. He approached the knife drawer, looked through the knives, saw the smaller knives, and approached the knife block, grabbed the larger knife to introduce into the encounter while the victim was entering his home. Yes.
Ms. Kuzak, I didn't ask why you believed it. I only asked if you did. And it sounds like
I'm just laying foundation.
Unnecessary. Let's talk about the identity of the suspect. You can't identify who entered Mr. Brackman's home.
The perpetrator was wearing a mask, so no.
You can't identify who killed Mr. Brackman.
You can't identify who killed Mr. Brackman from the videos, if that's what you're asking, but based on my expertise, yes, I can make a very evidence-based conclusion, yes.
Well, you can't identify the intruder's gender.
Are you speaking to the videos?
You can't identify the intruder's gender.
From the evidence that I was given, I can make a conclusion of who the perpetrator is.
And who is that perpetrator?
Avery Becker.
Ms. Kuzak, is that your testimony today, that Avery Becker is the perpetrator?
That Avery Becker is the one who was in the Ring security videos and who murdered Mr. Brackman? Yes, that is my conclusion.
That's your statement today.
That's just based on my investigation.
Sounds like that isn't your statement today. Ms. Kuzak, you prepared a statement for today's case.
I did, yes.
You signed that statement.
Yes.
Confirming that it was accurate.
Yes.
It was truthful.
Yes.
And it contained, by signing that statement, it contained everything you thought could be relevant to the events you discussed.
Yes.
And nowhere in that statement, you even name Avery Becker.
In my CSR work, which I completed and mentioned in my statement, I mention Avery Becker as a suspect, so.
In that statement that you prepared, that you swore contained everything to be relevant to the events you discussed, you do not say Avery Becker is the perpetrator, do you?
In my statement, I specify Exhibit 17, which is my CSR witness tracking sheet, in which I notify Avery Becker as the prime suspect.
That wasn't my question. In your statement, you do not mention Avery Becker. And it sounds like your answer is yes.
Sure.
Finally, Ms. Kuzak, you can't identify the skin color of the intruder.
No.
You can't identify the hair color of the intruder.
No, they were wearing a mask and gloves.
That's right. The only thing you can conclude about who committed this crime is the general height and build.
Yes.
Thank you, Ms. Kuzak. Your Honor, I have no further questions at this time.
All right, thank you. Ms. May, do you have any redirect within the scope of the cross?
Yes, Your Honor.
Go ahead.
Ms. Cusack, what did the Ring doorbell videos show you about the perpetrator?
The Ring doorbells showed me that the perpetrator matched the exact general height and build of the defendant, Avery Becker.
And in the photographs you analyzed, what did the knife block show you?
that there was an empty slot for a large chef's knife, just like the one that we retrieved from the crime scene.
Thank you. No further questions, Your Honor.
All right, thank you. Mr. Powell, do you have any recross within the scope of the redirect?
No, Your Honor.
All right, thank you. Then the witness is excused. Now, scoring panelists, if you may take some time to do your scoring.
I'm done.
All right, thank you. Prosecution, you may call your next witness.
Your Honor, the prosecution calls Detective Markowitz.
Ms. Markowitz, I remind you, remain under the oath you took at the beginning of this session.
Yes, Your Honor.
Ms. Seneschal, go ahead.
Can you hear me okay, Your Honor?
Yes, I can.
Good afternoon, Ms. Markowitz. Could you please state your name and spell your last for the record?
Yes, Jordan Markowitz, Markowitz.
Detective, what is your current occupation?
I'm a homicide detective with the Denver Police Department.
And how long would you say you have been working in law enforcement?
I started with the DPD 13 years ago, and then for being a homicide detective, I've been doing that for 7 now.
And do you have any specialized training as a detective?
Yes, as it pertains to this case, I have received specialized training with cell phones. I completed a training course and I received my certification in cell phone technology and forensic data recovery from the American Academy of Law Enforcement.
Okay, and how often do you use that that training in your work as a detective?
Constantly. I mean, I've downloaded the contents of literally hundreds of phones and I've interpreted cell tower data just like the one in this case in over 50 cases, I think, similar.
Your Honor, based on this witness's extensive experience, training, and certification from the American Academy of Law Enforcement, we move to enter Detective Markowitz as an expert in homicide investigation, as well as cell phone data recovery and analysis pursuant to Rule 702.
Ms. Proctor, do you have an objection?
No objection, Your Honor.
All right, then Detective Markowitz is admitted as an expert witness in the field of homicide investigation and cell phone data recovery and analysis.
Thank you, Your Honor. Detective, how did you become involved in this case?
So on March 6th of 2020, I was assigned to investigate the death of Mackenzie Brockman.
And did you visit the crime scene?
Yes, I was able to visit the crime scene immediately after it occurred.
What did you observe upon arriving?
So when I arrived, the front door was open and the victim was face down on the floor just inside the residence in a pool of his own blood. It was pretty gruesome. A large knife was visible on the floor just past the body that had clearly been used to stab Mr. Brockman.
And what did you do after making these observations?
So I observed this from the front porch, and then I walked around the house observing 3 Ring doorbell cameras, and then I actually entered the residence through the back door. The whole scene was absolutely in disarray. In the dining room, there was a chair knocked over, and there was a broken plate on the floor, and I was also observed some blood drops. And like Kuzak said before me, this was obviously evidence of a struggle.
Okay, so what else did you...
Objection, Your Honor. Interpreting blood and blood drops and forensic analysis in that manner is not what within the bounds of what Detective Markowitz has been entered in.
Ms. Seneschal?
Yes, Your Honor. This witness is not, as Ms. Proctor said, interpreting the blood drops. She's simply speaking to that she observed blood drops at the crime scene.
Response, Your Honor?
Yes, go ahead.
Detective Markowitz testified that those pieces of evidence, including the blood drops, led her to believe that there was clearly a struggle, and that is clearly interpreting evidence.
Ms. Seneschal, any response?
Yes, Your Honor. I would be more than happy to lay a little more foundation as to why Ms. Markowitz came to the conclusions that she did.
All right, go ahead.
Move to strike the testimony on drawing conclusions from the blood droplets, Your Honor.
Well, that's granted, subject to the additional foundation and perhaps readmitting it. Go ahead, Ms. Seneschal.
Ms. Markowitz, you have observed many crime scenes.
Yes, that is my job.
And why would you conclude that blood drops are evidence of a struggle?
I mean, I would say that my observation or my conclusion of a struggle was really mostly based on the broken plate and tipped over chair. So if that's all the evidence we need, that clearly demonstrates a struggle.
Okay, so moving on, Ms. Markowitz, what other observations were you able to make inside the residence?
So as I walked into the kitchen, I noticed a partially open kitchen drawer, which contained several knives, and also a knife block, which had a large open empty slot.
Okay, so what conclusions did you draw from these observations?
As I mentioned earlier, the evidence of a struggle, as well as this new knife evidence, led me to conclude that Brackman had confronted the intruder with a large knife from the kitchen, and it is evident that the intruder then got control of the knife and stabbed Mr. Brackman in the back.
So in your expert opinion, do you believe the intruder entered the residence with a knife?
Based on the open knife drawer, knife block, and the struggle, I believe that the knife came from inside the home.
Okay, what did you do next in your investigation, Ms. Markowitz?
It is always my practice to turn to the evidence to see who committed this crime. So I first downloaded the contents of Mr. Brackman's phone, and I knew from personal experience that he was a defense attorney, but I also learned from his phone that he was really into something called mock trial. He was a coach at Colorado High School.
So what did you do after learning that?
I mean, I went through this guy's phone and he loved mock trial. So I actually ended up getting the contact information for kids on the team, and I contacted Alex Cifuentes and spoke with her over the phone.
And can you tell us a little bit about that phone call?
Yes, that phone call was my first big break in the case. Alex told me that another student on the team, Avery Becker, had texted her about a plan to trash Mr. Brackman's home to get revenge after being kicked off the team.
So what did you do after learning that Avery had actually texted about a plan to trash Brackman's house?
I mean, I knew this evidence was important. So I called Alex Cifuentes and her parents into my office for an interview. She told me more about the texts. I asked to see them, but she had forgotten her phone. And so afterwards, I asked her to send me screenshots of this text conversation.
Okay, and what did you do after the interview with Alex?
So I tried to interview Avery Becker, but she lawyered up and I was unable to. So then I got a warrant to search Avery Becker's phone, but her lawyer informed me that she had lost it. So finally, I actually got a warrant to get the cell tower records for the communications with Avery's phone.
Okay, and were you able to search Becker's phone?
No, like I said, I was not able to download Becker's phone contents, but I could use cell tower data to track it.
Okay, so could you tell us about how cell tower data helps investigation?
Absolutely. So cell towers are going to be super helpful because they give us a general idea of a phone's location.
And how do they do that, Ms. Markowitz?
So every time you make or receive a call or text, your phone is going to ping off what is usually the nearest cell tower, right? And so when we receive the data about the locations of these cell towers, we can actually figure out where a phone was throughout the day.
Detective, do you have an accessible copy of Exhibit 16 in front of you?
Yes, I do.
I now direct your attention to that exhibit. Would you identify it, please?
Yes, this is a diagram that I created of where I believe Avery Becker's phone was on that day.
And how do you know this?
I was the one who made it.
Is it a fair and accurate representation of that diagram?
The one in front of me is absolutely yes.
Your Honor, we move to enter Exhibit 16 into evidence at this time.
No
Ms.
objection.
Brock, no objection?
No objection to Exhibit 16, Your Honor.
All right, then Exhibit 16 is admitted into evidence.
Your Honor, permission from my co-counsel to screen share this exhibit.
Granted.
And Your Honor, permission for the witness to annotate this exhibit using Zoom features.
Well, that's certainly beyond my expertise, but is there an objection from the defense?
No objection, Your Honor. Under competition rules, annotation is allowed.
All right, go ahead.
Detective, could you tell us a little bit about this exhibit?
Right, so our red arcs right here, we've got 3 of them. Those are going to show the antennas that Avery's phone pinged off through the day. So this, you can see, I don't know if that font's pretty small, but you can see we had a communication going to Avery's phone here at 12:47, one down here at 12:55, and then down here we've got 105, 106, and 117. So at those times, Avery Becker's phone pinged off of these towers.
And did Becker's phone receive any other communications later on the day of the murder?
No, Avery Becker's phone ceased all communication at 13:20 hours. I believe it was turned off after the murder.
So what conclusions were you able to make based off of this cell tower data?
Well, it is clear that Becker's phone was moving. And if you'll see this dotted line that I've drawn, it's pretty clear where to. So here is Avery Becker's house. Here's Mr. Brackman's house. And this dotted line is the path that I believe that she took. So clearly, as her phone pinged off those towers, she traveled from her own home to Mr. Becker's home.
Thank you. This exhibit can be taken down from screen share. Detective, in your expert opinion, how was Mackenzie Brackman murdered?
The evidence has shown that Avery Becker went to Mackenzie Brackman's house on Friday, March 6, 2020, with an intent to trash Mr. Brackman's home for being kicked off the team. Avery did not intend murder, which is why she did not bring a knife to the scene. When Avery approached the residence that day—
Excuse me, Ms. Makowitz, do we have an objection?
Yes, opinion on the ultimate issue. Detective Markowitz is speaking to the integral elements of today's case and linking the defendant to the crime, and experts are not allowed to opine on the ultimate issue. And it goes to the intent or state of mind included in burglary.
Ms. Senishin?
Your Honor, this witness has laid sufficient foundation to provide the conclusions based on her investigation as an expert. And this is her expert opinion that she's simply stating for the jury today.
Response, Your Honor?
Yes.
Just because it is an expert opinion and because her evidence is admissible does not mean that her conclusion is admissible. In fact, because it said that they went to the house with the intent to vandalize, that goes to the state of mind of the defendant, or the intruder, which is improper opinion because it is opining on the ultimate issue.
Well,
Under rule,
go ahead. Under rule what?
under Rule 704.
Well, under Rule 704B, an expert opinion is not allowed to opine as to the mental state of a defendant or the condition that constitutes an element of when that condition constitutes an element of the crime. I don't hear this as testifying to mental state. Am I missing something here?
By saying that she went to the house with the intent to vandalize, that goes to the mental condition and mental state of the intruder and one of the elements therein.
All right, Ms. Senishin. Do you have a
Your
response?
Honor, yes, Your Honor. Ms. Markowitz did speak about Avery's intent, but she already testified to this intent earlier in her testimony. She is basing this conclusion off of evidence already in this case. She's basing this evidence off of the text messages that she referred to earlier.
Final response, Your Honor?
Yes.
To say that she had intent is improper, regardless of if evidence that helped her form her conclusion came in. The conclusion that she had intent remains improper.
Okay, Ms. Senishin?
No response, Your Honor. I think I've demonstrated that this witness is testifying as to something she already spoke about earlier and is already in evidence.
Well, I think that under Rule 704B, the testimony as to the intent is not a proper subject for the expert witness's opinion. And to the extent that the testimony includes that statement about intent, it will be stricken. Otherwise, it stands. Thank you.
Yes.
Thank you, Your Honor.
Go ahead.
Detective, going back to what happened on the day of the murder, what happened, based on your expert opinion, when Avery arrived at Brockman's residence?
Yes, so as Avery approached the residence that day, the ring security system alerted Brackman to the intruder's presence, so he armed himself with a knife. He then confronted Becker, but Becker got the knife in a struggle and fatally stabbed Brackman. Brackman ended up dying in his own pool of blood near the front door.
Thank you, Your Honor. No further questions.
All right, thank you. Ms. Proctor, do you have cross-examination?
Yes, Your Honor.
Go ahead.
Good afternoon, Detective Markowitz. My name is Madeline Proctor. Let's begin with your arrival on the scene. You were called to 444 South Flower Street on March 6th.
Yes, there was a 911 call dispatched.
Right, and upon arrival, you unfortunately saw Mackenzie Brackman dead on the floor.
Yes, it was pretty horrific.
So naturally, you started to try and put the pieces together, right?
Yep, as any good investigator does.
Let's talk about how you did that, starting with the ring videos. The ring videos do not show any identifiable suspect, correct?
They show the height and build of Avery Becker, but no, they don't show exactly who it is.
And right, they just show a person in a Halloween mask, hoodie, gloves.
Yep, who looks to be the height and build of Avery Becker.
We'll talk about that. For now, let's move on to the cell tower records. Cell phones don't always connect to the nearest tower, do they?
Yeah, there's a pretty complicated algorithm for how they do.
Right, so that's a yes.
Yeah.
And they aren't 100% accurate then?
The records we have are 100% accurate. What was your question?
Sorry. Detective Markowitz, cell tower data is not 100% accurate.
It is accurate in telling us what antenna the phone connected to, yes.
Is it your testimony here today that inaccurate in determining the location of the person with the phone?
Right, so yes, I understand your question now. So it sometimes can be a different cell tower than the nearest one, I understand, yeah.
Thank you. And let's move on now to how you got to Miss Becker in your investigation. You talked to Miss Cifuentes, correct?
Yeah.
And she was the first person you spoke with?
She was the first student on the mock trial team that I reached out to, yes.
So she told you about how another student, Miss Becker, possibly had plans to trash Miss Coach Brackman's home.
Which was pretty similar to the scene I had witnessed. So yeah, that really tipped me off.
Right, so you called Miss Becker and her parents for an interview.
Miss Cifuentes and her parents, yeah.
Cifuentes and her parents for an interview. And you were going to talk about the text messages.
Yeah, I just wanted to overall hear Miss Cifuentes' sort of side of the story, because she also knew Mr. Brackman.
And part of that is the text messages?
Absolutely, yes.
But Ms. Cifuentes didn't bring her phone.
Yes, she had forgotten it that day of the interview.
And you never asked her why she forgot it?
That's not in my statement. Would you like me to answer that?
No, that's okay. You never asked her to bring the phone.
No, I thought that screenshots would be sufficient.
Right, you asked her to send you screenshots instead.
Yes, of the text conversation.
Now, just to be clear, Ms. Cifuentes does not have any training in handling evidence of that caliber, does she?
No.
And you got that screenshot a full day later.
Yes, after the interview.
Right. So after you got that screenshot, you decided to follow up on Avery Becker.
Yeah, those texts were really pointing towards Avery Becker.
And she was the only suspect that you followed up on.
That is not in my statement. Do you wish me to answer that?
We'll talk about how it's not in your statement. Is it your test? You provided a statement for today's case.
Yes, I did.
And that statement you signed?
Yes, I did.
Swearing that it was accurate?
Mm-hmm.
Truthful?
Yes.
And swearing that it was complete with every relevant detail?
Relevant to the case of Avery Becker versus the state of Colorado, yes.
Right. And nowhere in that statement do you mention investigating any other suspect, do you?
Nope. As I said, this is the trial of Avery Becker.
So you don't think that your investigation, including other suspects, is relevant?
I didn't include it in my affidavit, no.
Let's take a look at Exhibit 16, if my trial technician could please pull that up. Thank you, Mr. Powell. And this is a copy of the cell detail records that you prepared, correct?
Yeah.
And on this document, there are 3 locations marked with a pin.
Yes, Avery Becker's house, Blair Rollins' house, and Mr. Brackman's house.
Right, Blair Rollins' house is marked.
Yes, it is.
And Blair Rollins' house is in the same cell tower arc as Miss Becker's house.
Yes, it is.
So from these records, you concluded that Miss Becker could have left from, or the person with the phone, could have left from Miss Becker's house and made it to Mr. Brackman's house, right?
Yes, the dotted line is the path.
But because they're in the same cell tower arc, the person who left with the phone could have also left from Blair Rollins' house.
That is not in my statement. Would you like me to answer that?
I'm not asking you to refer to your statement. I'm simply asking you to refer to the exhibit which you prepared. And it looks like because they're in the same cell tower arc, the person could have made it from Blair Rollins' house to Coach Brackman's house.
Sure, they could have.
And you never spoke, thank you, Mr. Powell, you can remove Exhibit 16. And you never spoke with Blair Rollins, did you?
That's not my statement. Would you like me to answer that?
You did provide a statement for today's case.
Yes, I did.
And you swore that it was accurate, complete, relevant.
Yes, I did.
And nowhere in that statement do you mention Blair Rollins?
I do not, no.
Or speaking to him?
I do not, no.
Because he's missing, right?
I couldn't tell you that because it's not in my affidavit.
So you never mentioned investigating any other suspect other than Miss Becker in your affidavit?
Not in my affidavit for the case of Avery Becker versus the state of Colorado.
Thank you, Your Honor. Thank you, Detective Markowitz. No further questions at this time.
All right, thank you, Ms. Proctor. Ms. Senishin, do you have any redirect within the scope of the cross?
Yes, Your Honor.
Go ahead.
Detective Markowitz, why did you not look further into Blair Rollins in this case?
As I said, I could tell you all about my investigation of Blair Rollins, but it's not in my statement. I prepared my statement for the case of Avery Becker versus the state of Colorado.
Thank you so much, Ms. Markowitz. No further questions, Your Honor.
All right, thank you. Ms. Proctor, do you have any recross within the scope of the redirect?
No, Your Honor. Thank you.
All right, thank you. Then the witness is excused. Scoring panelists may score their sheets.
I'm done.
Okay, thank you. The prosecution may call its next witness.
Thank you, Your Honor. The prosecution calls Miss Alex Cifuentes to the stand.
Ms. Cifuentes, I remind you, you remain under oath that you took at the beginning of this proceeding.
Yes, Your Honor.
Permission to proceed?
Go ahead.
Good afternoon. Please introduce yourself to the jury.
My name is Alex Cifuentes, Sifuentes.
Alex, where do you go to school?
Currently a senior at Colorado High School. Go Eagles.
What kind of activities are you involved in?
Well, I recently joined the Ping Pong Amateurs Club, but my favorite and certainly most time-consuming activity is mock trial.
Could you tell the jury about your involvement in mock trial?
Sure. I've done it all 4 years of high school. I love it. I'm usually an attorney. I always await the day that our coach would give out the roles and I go home and dig right into the case.
Do you see anyone here today who did mock trial with you?
Yes, I've seen Taylor Perkins and Avery Becker.
Were you friends with the defendant?
Of course. I was good friends with Avery. We were on the team all 4 years together. You're bound to get close with someone who you spend hours and hours a week with. Yeah, we have a really good friendship. She was the person who introduced me to mock trial my freshman year.
What was the defendant like on the team?
Avery was really good at mock trial. She was a really good witness, a really good liar on the stand. She was a really good actress. The problem was she didn't put in a lot of work. She would come unprepared to practice. She would come late. I didn't really like how she treated our coach.
How did she treat Mr. Brackman?
She would constantly refute his advice, ignore his edits on directs and crosses. He was a real lawyer, a real criminal defense attorney. He knew what he was doing and she would completely ignore it. She showed up to regionals really, really unprepared, just flying off the handle, and Brackman demoted her to B team for that.
Did she react in any way to this demotion?
She threw a fit. She threw an absolute fit. At that point, if A team had lost another person, we were not going to be able to go to state. So all of a sudden, her friend Taylor Perkins quits the team. So she has to be let back on, which she was, but not for long.
How come she wasn't on for long?
Well, even though she won a bunch of awards at regionals, like Best Witness and I think Best Closer, she totally went off her notes, totally came unprepared. And coach basically got on her about how you can't do that in the real world. You can't just walk into a trial unprepared and expect your client to run free. That's malpractice. And he explained this to her and she left practice fuming with a Sharpie.
What did she do with the Sharpie?
She went out into the parking lot where Mr. Brackman's car was, climbed up on his super sweet 911 Porsche and wrote "Worst Attorney Award" in big bold letters.
Did Mr. Brackman press charges for this?
Proper character evidence.
I'm sorry, Ms. Vera?
Objection, improper character evidence.
Ms. Humber?
Could co-counsel confirm which part of the statement is improper character evidence?
Ms. Vera?
The testimony about the events that took place between Avery Becker and the car of Mr. Brackman.
And could you state why that testimony regarding writing with a Sharpie on a car is character evidence?
Yes. Under Rule 404, this is improper character evidence. The prosecution, or if this testimony is allowed to enter, the effect of this testimony the effect of the testimony that will be felt by the jury. It may lead to them believing because of past events that this testimony refers to, the defendant would end up vandalizing Coach Brackman's house. This testimony is being used to show propensity in today's case.
Ms. Humber, do you have a response?
Your Honor, this is not being offered to show that the defendant acted in accordance with this behavior on any particular occasion. Rather, it is to provide the evidence between the animosity of Mackenzie Brackman and the defendant, who in this case is the victim.
Response, Your Honor.
Yes, Ms. Barrett.
Even if the prosecution is claiming that it shows the relationship between Mr. Brackman and Avery Becker, its probative effect is heavily outweighed by the prejudicial effect it would have on the jury. So it cannot be allowed to enter in today's case.
Does that mean you are changing your objection to a 403 objection? That being you're objecting because the potential prejudicial effect outweighs the relative or the relevant evidence?
Yes, Your Honor. I will switch to that.
Okay, Ms. Humber, do you have a response to that?
Your Honor, in no way is this offered to prove a prejudicial value. This is a key issue up for debate in today's case. It is in no way misleading the jury or wasting time, as it is proving the animosity between Mackenzie Brackman, the victim, and the defendant.
Okay, well, I would suggest to you that if you're putting evidence in, you're probably doing it for prejudicial effect. And the question is whether it's unfairly prejudicial. In this case, Ms. Varick, I don't think that there is anything about this that relates to character or is something that would mislead the jury or waste time. There's a discrete series of events that the witness is testifying to, and the jury can take those events into consideration in weighing what happened in this case. So the objection is overruled. Ms. Humber, go ahead.
Yes, Your Honor.
Go ahead.
Did Mr. Brackman press charges for riding on the car?
Not that I know of, no. Avery's only punishment was getting kicked off the mock trial team permanently this time.
Did the defendant accept this punishment?
Definitely not. She basically went around texting me and the entire team asking them to help get Brackman, help talk to Brackman to get her back on.
Your Honor, permission for this witness to view their own copy of what has been previously marked as Exhibit 14.
Yes, go ahead.
Ms. Cifuentes, do you have this document?
Yes, I do.
Do you recognize it?
Yes, these are the screenshots of the text exchange that I had with Avery that I sent to the detective.
Is it a fair and accurate representation?
Yes.
Your Honor, we move to enter Exhibit 14 into evidence.
Ms. Varick, do you have an objection to the Exhibit 14?
Yes, Your Honor. Objection to hearsay under Rule 801.
And could you explain that objection further?
Yes, this is a out-of-court statement that is being offered for the matter asserted, so it should not be allowed to enter in today's trial.
Ms. Humber, do you have a response?
Yes, Your Honor, pursuant to 801 D1 and D2, herein are statements made by the party opponent, in this case the defendant, and as well as Ms. Cifuentes' the declarant's prior statement. Additionally, these are not being offered for the truth of the matter asserted, but the effect on the listener, in this case the listener being Ms. Cifuentes.
Response, Your Honor.
Ms. Varick, go ahead.
The proper foundation has not been laid that these text messages came from Avery Becker, so the use of this statement by a party opponent cannot be used in today's trial. If Detective Markowitz had properly downloaded data to prove that these texts were sent by Avery Becker, then we would not be having this argument, but there is no way to truly prove that these were sent by Avery Becker, so they cannot fall under the party opponent exception.
So at this point, you're changing your objection from a hearsay objection to a foundation objection. Is that right?
Well, not exactly, Your Honor.
Please explain.
I'm saying that there is no possible way for them to lay enough foundation that will truly show that Avery Becker has sent these text messages. So it cannot be proven that this is sent by a party opponent.
So you're saying as a precondition to proving the exception to the hearsay rule, there has to be adequate foundation to say that this is actually a statement from the defendant.
Yes, Your Honor.
So your objection is foundation. So Ms. Humber, do you have a response to that?
Yes, Your Honor. The prosecution is moving to enter this exhibit by the truth of it being a screenshot. As the authenticity of these messages is a key issue in this case, any issues with their truthfulness can be addressed on cross. For this matter, Alex Cifuentes is allowed to testify to her truth of seeing them based on her rational perception without including any scientific knowledge pursuant to Rule 701.
Well, from your testimony that you have elicited so far, and from the testimony from the investigating officer, it's not clear that these screenshots were actually generated in the cell phone that Ms. Cifuentes says they came from. So is there some way for you to lay foundation that these are actually generated by the cell phone and not some doctored evidence?
Absolutely, I can lay further foundation with this witness.
All right, go ahead.
Ms.
Please do.
Cifuentes,
Sorry.
May I proceed?
Yes.
Ms. Cifuentes, do you remember receiving these texts?
Yes, this was a conversation I had with Avery.
This was a real conversation between you and the defendant?
Yes, absolutely.
To clarify, I'm referring to the messages on the left. You have recollection of receiving the gray messages from the defendant on the left?
Yes, I do.
And do you have recollection of sending the messages in green on the right?
Yes, I sent those texts.
Were these messages in any way fabricated or altered?
No, these were exactly what it looked like on my phone as I took a screenshot.
This document shows exactly as you perceived them?
Absolutely, exactly.
And you signed the testimony into case and understand the weight of that?
Yes, absolutely.
Your Honor, we move to enter Exhibit 14 into evidence.
All right, Ms. Vieira, do you have a further objection?
Yes, Your Honor. There is still no way that Alex Cifuentes would know if Avery Becker specifically sent these text messages. So even if she testifies that she remembers receiving them and she sent these text messages, we cannot know about Avery Becker's side.
Okay, well, it does not seem to be in dispute that there were text messages generated by the defendant's phone. There seems to be some dispute as to who may have had that phone, and there seems to be some dispute as to whether these are actually generated from the phone and not created from some other means through a screenshot. Those are things that you can explore on cross-examination, but on the basis of the foundation that is laid in this testimony, I'm going to overrule the objection and admit Exhibit 14 into evidence.
Yes, Your Honor. Permission for our technician to show Exhibit 14 to the jury?
Go ahead.
Thank you. Ms. Cifuentes, could you give the jury a summary of the defendant's request?
Yes. Is it okay if I annotate?
Your Honor, is it okay if my witness annotates on this document?
Okay, so basically here,
Just Ms. Cifuentes, does the defense object to annotating the exhibit?
No, Your Honor, we do not.
All right, thank you. Go ahead.
Your Honor, before we continue, could I ask our technician to move the document to page 2? Thank you. All right, Ms. Cifuentes, could you give the jury a brief summary of the defendant's request?
Yes. So basically right here, I received a text asking me to go talk to the coach about having her back on the team.
What did she say next?
Well, I explained like the coach was really upset. And she said, come on, please. It's really important to me. But I actually did go talk to the coach about it because I wanted to go to state, and without Avery, we were not going to be able to go to state. So I explained to her, like, he didn't change his mind. He completely shut me down. And she said here, well, if he's still upset about his car, then he's gonna be really upset when he sees what I do to his house. And then here I asked her, what are you gonna do to his house? And she said, I'm gonna wait until he's at work, break in and trash it, referring to his house.
I see. And did you ever ask what she meant by that?
No, I basically told her, I don't think that's a very good idea, but I should have, I guess, but I never did.
Ms. Cifuentes, did you see the defendant on March 6th?
No, Avery was not at school that day. And the next thing I knew, Mr. Brackman had been murdered.
Thank you, Ms. Cifuentes. Your Honor, no further questions at this time.
All right, thank you. How much time is left for the prosecution?
Your Honor, 32 seconds remain currently for the prosecution's direct.
All right, Ms. Humber, you have 32 seconds if you choose to redirect. Ms. Furyk, you have cross-examination.
Yes, Your Honor.
Go ahead.
Ms. Fuentes, let's start by talking about your mock trial experience.
Sure.
You were on mock trial with Avery Becker.
Yes.
You were close friends?
Yes, really close friends.
You also believed that you were equal when it came to mock trial.
Yeah, I would say so. We both worked pretty hard.
Yes, you always came prepared to practice?
Always, yes.
You tried to have all useful information memorized.
Yeah, like rules and scripts and stuff.
But Avery Becker usually came late.
Yes.
But Avery was the one who won multiple awards at competition.
She did win awards, yeah.
Later on, you reached a point where you talked to Coach Brackman about Avery Becker.
Yes, I did.
You asked him why he kept Avery Becker on the team.
I did.
Later on, Avery was demoted to B team.
Yes, she was, for being rudely unprepared for regionals.
You believed that she was rightfully demoted.
Yes, she came completely unprepared. I believe it was a rightful demotion.
But she ended up getting back on the team.
Yes, her friend Taylor, he quit the team.
Then she got kicked off the team entirely.
Yes, yeah, for vandalizing Coach Brackman's car.
Again, you believed that this was for the best.
Yes, I don't think she deserved her spot on the team.
And you were excited to take on larger roles now that your best friend, Avery Becker, was kicked off the team.
Yes, I love mock trial. I was excited for the challenge.
Now let's talk about these text messages you received.
Sure.
Like we mentioned, Avery Becker was kicked off the team.
Yes. Yes.
And afterwards, you received texts begging for help to get her back on the team.
Yes.
You responded by saying you would help, and you went and made an impassioned plea.
Yes, I begged Mr. Brackman.
But this didn't help, did it?
No, he completely shut me down.
So you texted Avery Becker that Mr. Brackman wasn't backing down, didn't you?
I said I could try, but after the car situation, I doubt anyone would change his mind.
I'll restate my question. I think you don't understand. Within your statement, you say, I within your statement, you say you texted Avery Becker that Mr. Brackman wasn't backing down.
Right, but I didn't actually text her that.
But within your statement, it says you texted her this, doesn't it?
Sure, yes.
Now, you should have access to Exhibit 14, so if you'd like to refer back to this, please do.
Yes, I have it right here.
Starting at the 5th bubble down, Avery Becker continues to ask for help.
Yes, she says, come on, please. It's really important to me.
Yes. And you do not respond by specifically saying, I will help, do you?
No.
You just say, I guess I could try.
Yes, I did say that.
Nowhere within these texts do you say, Mr. Brackman isn't backing down, do you?
No, I say I doubt anyone could change his mind, which, yeah.
You don't say, Mr. Brackman is.
No.
Okay. Now let's talk about how you handled these text messages. When you first received them, you didn't show them to Coach Brackman, did you?
No, I didn't.
You didn't give them to the police?
When? Sorry?
When you first received them, before you heard about them.
That's not in my statement. Would you like me to answer?
No, Ms. Fuentes, it's fine. Now, you eventually were called by Detective Markowitz, and you offered up these text messages as evidence.
Yes. I offered to, yeah.
Yes. And he asked you to come down to the station for an interview.
Yes, she did.
You didn't bring your phone to this interview, did you?
No, it was sitting on my desk charging.
I'm not asking why you didn't bring it. I'm simply asking, did you bring your phone? And your answer is
no. I did not have my phone at the interview.
Your Honor, apologies for the interruption, but according to my timekeeping, the defense is now out of time for their cross-examination. However, I do believe there's a discrepancy between the defense's timekeeper and myself.
Sounds like there may be. Could we have the defense timekeeper, please?
Yes, Your Honor. I have 1 minute and 43 seconds remaining.
Your Honor, I have been recording times, and I noted a time discrepancy earlier, right around when the defense put in their 10-minute mark, and I've been recording times for all previous cross-examinations.
Okay, did you turn off the time during objections?
I did.
Ms. Sayers, did you notice the discrepancy?
No, I did not, Your Honor.
Okay. Ms. Varick, how much time do you have left, do you think?
I believe I'm on 2 questions left, so I should be done in under a minute.
All right. Noting the discrepancy and that it came pretty late in the day to try to address it, I'm going to let you ask your final 2 questions. So go ahead. Yes.
Very briefly, I will note that in the Colorado Bar instructions, it does state that time discrepancies should not be brought up until the end of the segment. So my apologies for mentioning it sooner.
Okay. That I didn't mean that as a criticism, Ms. Burlock, but thank you. Okay, go ahead, Ms. Varick.
Thank you. The detective said you could send screenshots.
Objection
yes,
calls for hearsay.
Response, Your Honor.
Yes.
I can rephrase the question.
No, let me ask the question. I think what the detective already established that he asked her to send screenshots. So I'm not sure what the point is. Go ahead.
The detective said you could send him screenshots.
Yes, I could send her screenshots, yes.
You didn't send those screenshots the second you got home after just being at a murder investigation, did you?
I don't remember when I sent the text. Would you like me to answer?
Within your statement, you say you sent them the next day, don't you?
Oh, then yes, I did send them the next day.
So I'll go back to my last question. You didn't send them the second you got home after just getting home from a murder investigation, did you?
If you would let me respond to my earlier question, my phone's battery was being really finicky and I couldn't really keep a charge. So, I mean, my phone was kind of off and on, and I guess it finally kept a charge the next day.
That's a no, correct?
No to your question?
Yes.
I didn't send them immediately after the interview.
Thank you. No further questions.
All right, thank you. Ms. Humber, you have 32 seconds for redirect if you want to use them.
Yes, Your Honor, briefly.
Go ahead.
Miss Fuentes, when did you send the police officer these text messages?
I sent them the next day.
Did you send them as soon as you remembered to?
Yes, I did. As I was saying earlier, my phone's battery was not holding a charge. That's why I didn't take it to the meeting initially. But when my phone finally got around to working, I sent the texts.
And are these texts fair and accurate representations?
Absolutely. This is the exact conversation I had with Avery.
Thank you, Ms. Fuentes. Your Honor, no further questions at this time.
All right, thank you. The witness is excused.
Again.
Okay, thank you. All right, thank you. Does the prosecution have any other witnesses?
No, Your Honor. At this time, the prosecution rests.
All right, thank you. Defense, are you ready to go?
Yes, Your Honor. The defense calls Mr. Taylor Perkins to the stand.
Mr. Perkins, I remind you remain under the oath you took at the beginning of these proceedings.
Yes, Your Honor.
Go ahead, Ms. Proctor.
Good afternoon, Mr. Perkins.
Good afternoon.
My name is Madeline Proctor. Please introduce yourself to the jury.
My name's Taylor Perkins. That's Perkins.
Mr. Perkins, where did you go to high school?
I went to high school at CHS, Colorado High School.
Did you know a Miss Avery Becker during your time there?
I did, actually. Avery was one of my best friends. You know, we had classes together. We hung out after school. I mean, we played video games on my phone. We even hung out on the weekends, and we also did mock trial together.
Sounds like you two were pretty good friends. Tell us more about your mock trial team.
So our mock trial team was actually pretty good. I mean, I think we were the favorites to win state, just as long as like arguments on the team weren't getting in the way.
What do you mean by arguments?
So a lot of times at practices, people will get into arguments. I mean, especially Avery and our coach, Coach Brackman.
Why do you think that is?
Well, Coach Brackman really got on Avery always for showing up late or not having work done. Even though Avery always performed flawlessly, Coach was not a fan of it.
Did those arguments ever escalate?
They did, actually. There was one time where Coach Brackman got so heated, he demoted Avery to B team, which just wasn't fair.
Why wasn't that fair?
Avery was the best attorney on the team by far, and the best attorney deserves to be on the A team. That's just how it works.
So did you do anything to help your friend out?
I did, actually. I stepped down from the team so that the team would have no choice but to take Avery back. And it actually ended up working out really well because they did so good at regionals.
So when did they take her back on the team?
It was actually about a week before regionals that they took Avery back on the team.
And are you aware of her performance there?
I am. She won Best Attorney Award and Best Closing Argument. It was so cool.
That's great. Let's talk about the morning of March 6th now. What were you doing that morning?
That morning, actually, both Avery and I had first period off. And when that happens, Avery always picks me up for school. You know, we got to save gas money somehow.
So where did you two go then?
So on our way to school, I mentioned that Avery wasn't responding to my text, which was kind of weird. And it was at that point that we realized she didn't have her phone. So, you know, being seniors and like senioritis starting to kick in, we decided to skip school that day and go look for her phone.
Where specifically did you look for her phone?
We retraced the places that we had gone the day before. So we started by looking at the mall. We looked in every shop that we went into the day before.
After you left the mall, where else did you retrace your steps?
After the mall, we went to the Fry Shack because we actually had dinner at the Fry Shack the night before.
Did you run into anyone you knew while you were at the Fry Shack the night before?
Actually, yeah, while Avery and I were eating dinner, a couple of the members of the mock trial team came after practice. I specifically remember Alex Fuentes coming up and trying to sympathize with Avery for being kicked off the team, but it came off very passive aggressively.
I see. And when you were, where was the last place that you saw the phone?
It was at the Fry Shack actually during dinner. I think I remember like seeing Avery like set it down after like playing a game or something and went to the bathroom.
So then the next day when you were retracing your steps, did you run into anyone you knew that day?
We did actually. Ray ran into some of the mock trial kids at the Fry Shack while we were looking there. It was kind of weird. They would have normally been at practice at that time.
What's your understanding as to why they weren't at practice?
It's my understanding that Coach Brackman never showed up to practice that day. And you know, the whole like 15 minutes and you can leave thing when a teacher doesn't show up, apparently that's what they did.
Okay. So where did you end up finding the phone then?
Unfortunately, we never actually found Avery's phone, which really sucks. I mean, we spent the whole day looking for it, and Avery had to spend like $500 to buy a new phone. That's not cheap.
Let's talk about someone else now, Blair Rollins. How do you know him?
He was another student at CHS, actually. We had some class together. You know, I saw him around campus.
And are you aware of the relationship between Coach Brackman and Blair Rollins?
I am. It's my understanding that Coach Brackman defended Blair Rollins' father in a murder trial. And unfortunately, Blair Rollins' dad was sentenced to life in prison.
I see. Going back to the events of March 6th, was there ever a point in time when you and Miss Becker were apart?
No, we were together the entire day. I mean, other than like the 2 minutes she went to the bathroom, I mean, I waited outside, but she'd have to be like the Flash to go from the bathroom at the mall to Coach Brackman's house and back to the bathroom at the mall in that like 2 minutes. We were never apart that day.
Thank you, Mr. Perkins. Thank you, Your Honor. No further questions at this time.
All right, thank you. Ms. May, do you have cross-examination?
Yes, Your Honor.
Go ahead.
Thank you. Mr. Perkins, you've known the defendant, Avery Becker, for a long time, correct?
I mean, throughout high school.
And you're very close friends with Avery?
I would say so.
And you joined mock trial just because of Avery?
Well, you know, freshman year, I didn't have many friends, and Avery was one of my friends. So I joined mock trial so I could help make more friends. Yeah.
And you said you wouldn't have done mock trial if it wasn't for Avery?
Well, I wouldn't even known about it if it wasn't for Avery.
Thank you. And throughout this time at mock trial, you observed the relationship between Mr. Brackman and Miss Becker, correct?
That is correct.
You observed their fighting?
Yeah, unfortunately, it was quite often.
And you observed the tension between the two of them?
Yeah, I mean, almost every practice, it kept building and building.
And later on, when Avery was demoted and then further kicked off the team, when she was demoted, you quit mock trial for her, correct?
I stepped down from the team. I mean, I was supporting my friend. I mean, she was the one who was great at mock trial.
So you're an incredibly loyal friend.
Well, I mean, I was doing it to be a good friend, but also, I mean, the team benefited from having Avery on it.
And you were also Miss Becker's alibi for that day.
Well, I am. I mean, I was with her the entire day.
After Miss Becker was kicked off the team tried to get her back on.
I think so. I wasn't actually involved with most of this. I just heard Avery was texting some people. I don't know what actually happened with the other people she was texting.
Avery wanted on the team so bad that she even texted Miss Cifuentes.
Objection, Your Honor. Calls for speculation. Miss May is asking Mr. Perkins to speculate on Avery Becker's wants, her wanting to be back on the team, and her personal thoughts.
Ms. May?
Your Honor, I'm not asking for Mr. Perkins to testify to Avery's actual thoughts. This is based on the witness's perception between the relationship and solely based on the perception between Ms. Becker and the other teammates.
Response, Your Honor?
Yes, go ahead.
Ms. May, I believe the question was, Avery wanted to get back on the team so bad that, and I believe that Mr. Perkins has no knowledge of her personal beliefs. If you would have asked something along the lines of, from what you observed, then it would go to his proper lay witness opinion. But because it is asking for what she actually wanted, I believe that is speculation.
Well, I think that I'm trying to reprocess your objection, Ms. Proctor, because I thought what you were objecting to was the lack of foundation. How does he know that there was text going on among the team members, because he said that he wasn't part of it? If he learned that he was part of it, either it was through hearsay or perhaps through a statement from the defendant, in which case it was probably be admissible and not hearsay. But I think you need more foundation to get that information in if you want to.
Yes, Your Honor. The defense does agree that all of the testimony about Avery Becker texting with other people is hearsay. However, this objection was in regard to Mr. Perkins knowing what Miss Becker wanted, which is out of his knowledge. However, he could opine perhaps from his observations what it appeared to look like.
Well, I think he could state if the defendant told him something, then that would be admissible testimony. Otherwise, it's speculative. So I will sustain the objection. And if you want, Ms. May, you can go after it in a different manner.
Mr. Perkins, you and Avery discussed different ways for her to get back on the team.
Yeah, a little bit.
And through this discussion, you found out that Avery texted everyone on the team.
Yes, I did.
And everyone on the team would include Alex Cifuentes.
Well, everyone on the team could also be like a metaphorical statement, like
But you said
a lot of people. I did say everyone.
Did you, based on your observations of all the time you spent in mock trial, did you observe Ms. Cifuentes and Ms. Becker to be good friends?
I mean, on the surface, it seemed like they liked each other. I mean, I don't know what was going on down below. Obviously, I'm not like a psychologist or whatever the people who read your mind are.
Would you consider, based on your perception, Ms. Cifuentes and Ms. Becker to be good friends?
I mean, they didn't hate each other, if that's what you're asking. I wouldn't say they were best friends, but they didn't hate each other.
Yet Alex texted Avery trying to get back on. Avery texted Alex and trying to get back on the team.
I mean, I don't know if she actually did. Avery told me she did, but I don't know if she actually did.
Mr. Perkins, you were not at school the day that Mr. Brackman was killed, correct?
Like I already said, we were at the mall looking for Avery's phone.
So you were with Avery all day?
I was.
You called and texted the phone while looking for it?
Yeah, you know how like when you can't see your phone at your house, you call it so you can try to hear the ringer? That's what we were doing.
But you spent all day looking for it, yet you only called it 5 times throughout the day.
Well, if someone had it, I didn't want to annoy them. Like if someone had it in their pocket and were planning on returning it, I didn't want to like annoy them.
5 times throughout the day.
Yes.
And you didn't think to use Find My iPhone?
See, I have an Android and it just never crossed my mind to even use that.
You said that you were nowhere near Brackman's house that day.
We were at the mall in the Fry Shack. That's not even close to Mr. Brackman's house.
So you know where Mr. Brackman lives?
Well, of course, I've been on his team for a couple of years.
Mr. Perkins, prior to testifying here today, you spoke to Ms. Becker after Mr. Brackman was killed, but prior to the trial.
Wait, sorry, can you say that again?
Yes. prior to testifying here today, but post the murder of Mr. Brackman, you spoke to the defendant, Avery Becker, correct?
Yeah, I think so.
Discussed the murder.
What?
You discussed the murder is what I'm asking, if you understand that.
Well, she was telling me how it's crazy that it happened. I mean, she
And
didn't
in
do
this
it.
discussion, Miss Becker brought up the idea that Blair Rollins may be involved.
I mean, looking back at it, I would have never guessed it, but I mean, it makes so much sense now.
So the defendant in this case, the only suspect on trial, introduced the idea to you that someone else could have committed this murder. Is that a yes or no? The idea of Blair Rollins was introduced to you by Miss Becker, the defendant in the case.
Yeah, that is true.
Thank you. No further questions at this time, Your Honor.
All right, thank you. Ms. Proctor, do you have any redirect within the scope of the cross?
Yes, Your Honor. Mr. Perkins, why did you quit the mock trial team?
I quit the team in support of my friend. Avery was a great attorney and deserved to be on the A team and get to show her stuff at regionals. I mean, mock trial wasn't my favorite thing. I did it because I had friends that did it. And with Avery off the team, it wasn't the same.
In regard to Blair Rollins, have you seen him since March 6th?
No, I haven't seen him since March 6th.
And would you normally see him?
Yeah, I would have normally seen him at school, but you're right. Now that you mention it, I have never seen him since March 6th.
And on March 6th, would there have been any opportunity for Miss Becker to have left the locations where you were at?
I mean, other than, like I said, that 2 minutes she was in the bathroom, but I don't see how it's physically possible for her to get to one place to the other and back. I mean, we were never apart other than that.
Thank you, Mr. Perkins. No further questions at this time.
All right, thank you. Ms. May, do you have any recross within the scope of the redirect? All right, thank you. Then the witness is excused.
Yes, Your Honor.
Brenda, I don't want to push you, but are you done?
Yes, I'm sorry.
All right. Okay, thank you. Next witness, please. Defense.
Your Honor, the defense calls Blake Van Owen to the stand.
All right, thank you. Mr. Van Owen, I remind you that you remain under the oath you took at the beginning of these proceedings. Go ahead, Mr. Powell.
Good afternoon, Professor. Please introduce yourself to the jury.
My name is Blake Van Owen. That's spelled VANOWEN.
Professor, let's talk about your professional experience. Can you tell us about the time you spent on the Aurora Police Department?
I joined the Aurora Police Department for a 9-month period between 2005 and 2006. For the entirety of my professional career, I have always been dedicated and devoted to criminal justice. At first, I thought that the APD would be the best place for me.
Why did you leave the department?
When I was with the Aurora Police Department, unfortunately, I injured a young woman using police-approved practices. Don't get me wrong, I didn't intend to injure this woman. However, the way in which these practices are constructed led to this. I realized that these practices were not achieving the means of criminal justice, and they needed reform. So I stepped down from the APD so I could see justice happen.
How did you see justice happen?
I went down my own path, and I obtained my master's degree in criminal justice in 2014. By 2015, I began lecturing students at this University of Colorado on social practices and police practices.
Have you, other than teaching at the university, are you currently employed in the field of criminal justice?
Yes, I've been a private investigator for several years now. I'd like to consider myself as a check on the power of police.
Have you ever testified as an expert witness?
I've testified as an expert in over 100 trials. I regularly act as an expert in U.S. district and state courts.
In those courts, what were you recognized as an expert in?
I was recognized as an expert in crime scene reconstruction 8 times, an additional 5 times in cell tower analysis.
Your Honor, the defense requests the court to recognize Professor Van Owen as an expert in the field of police procedure, cell tower analysis, and crime scene reconstruction. Pursuant to Rule 702, his skill, knowledge, education, experience, and training have all been shown, and his testimony will assist the jury in understanding the evidence.
Ms. Humber, do you have an objection?
Yes, Your Honor. Permission for a brief voir dire.
Go ahead.
Good afternoon, Mr. Van Owen. You claim to
Good
be
afternoon.
an expert. You claim to be an expert in cell tower analysis.
Yes, that is what I'm being offered as for today. Yes.
Of the cases you've worked on, less than 5% have involved analyzing cell towers.
I've been recognized as an expert 5 times in professional court.
So that is less than 5% if you've been entered in over 100 cases.
That's correct. Yes, that is, yes.
You have no specialized training with cell towers.
Actually, I do. I mentioned earlier that I have a master's degree in criminal justice. Throughout that time, I did go through rigorous courses around cell tower analysis.
You have not listed specialized training specifically pertaining to cell towers, which is the key issue in this case.
I didn't specifically mention the cell tower analysis in my statement. However, again, as I said, through my experience with criminal justice, I did obtain this knowledge.
Okay. And you didn't list any specialized training in cell phone data.
Once again, that does come along with the package of master's degree in criminal justice.
Same with forensic software for cell phones?
Yes, that's correct.
Cell data records?
Yes,
Cell phone technology?
that's correct.
And forensic data recovery?
Criminal justice is a broad general term. That does include all of that, yes.
But you have not listed any specialized training pursuant to the areas I just listed.
Like I said, I did obtain my master's degree in criminal justice, and that is training or education in that field.
Your Honor, pursuant to Rule 702, we don't object to Mr. Van Owen being entered as an expert. However, we do object to him testifying as a cell tower analyst for lack of education, skill, knowledge, and training in the field.
May I respond, Your Honor?
Yes, you may, Mr. Powell.
On Ms. Humber's voir dire, sufficient foundation has been laid that his skill, knowledge, education, experience, and training have been shown, and only one of those needs to be shown to tender him or to recognize him as an expert in the field of cell tower analysis. Your Honor, he has received a master's degree in criminal justice, and during that time earning his degree, he has testified that he's gone through training and education with those cell tower and respective fields.
All right, thank you. I think the pertinent information for me, which has not gone challenged, is that he has been accepted as an expert in cell phone analysis 5 times in courts in the state and federal systems. And the court will follow those previous rulings by other courts and will admit the witness as an expert in the fields of crime scene investigation, police procedure, and cell phone analysis.
Your Honor,
It's overruled. Go ahead, Mr. Powell.
Your Honor, may I make a clarification?
Yes.
I tendered Professor Van Owen as an expert in cell tower analysis.
Cell tower, yes. Go ahead.
Professor Van Owen, how did you become involved in this case?
I was hired by the defense as a private investigator to investigate Kyle Kuzak and Detective Markowitz's investigation.
What have you done in preparation for this case?
For today's case, I reviewed Kyle Kuzak's crime scene reconstruction, Detective Markowitz's cell tower analysis. I've also conducted my own investigations in fields that I felt necessary.
Professor, let's begin with the cell tower analysis. Or let's begin with Detective Markowitz's cell tower analysis. What problems do you have with his report?
Frankly, Mr. Powell, Detective Markowitz in today's case suffers from a case of confirmation bias.
What is confirmation bias, Professor?
It is the tendency to interpret new evidence as confirmation of one's existing beliefs. In other words, it's like taking puzzle pieces and forcing them in the incorrect puzzle.
How does Detective Markowitz fall victim to this?
Detective Markowitz developed a preconceived notion that Miss Becker was the only suspect in today's case. They only focused on and noted evidence that would implicate Miss Becker while ignoring evidence that would exculpate Miss Becker.
What are some examples of this?
1, Detective Markowitz's assumptions on the cell tower data. 2, the validity of the text message screenshots. And 3, Detective Markowitz's lack of an investigation with Blair Rollins.
Let's begin with the cell tower analysis. How is this an example of confirmation bias?
Before Detective Markowitz pulled any of her data from the cell towers, they had their suspect, and her suspect was Miss Becker. Instead of following the cell tower data to their natural conclusions, Detective Markowitz tried to force that data to fit her story of Miss Becker being the main perpetrator.
What about the screenshots? How's that example of bias?
You see, there are 2 aspects of confirmation bias within Detective Markowitz's analysis of the text message screenshots. She fails on identifying who sent them and from where they were sent.
Why don't we know who sent them or where they were sent from?
The name on an iPhone can be easily manipulated. Detective Markowitz saw that the name said Avery Becker and automatically assumed that they were from Avery Becker. Furthermore, Detective Markowitz didn't obtain the phone to download the data from it, so we don't know where the phone was at. Look, Detective Markowitz is an expert in downloading cell phone data, yet she didn't download any of the data on the phone at all.
Let's talk about Blair Rollins. First, who is he?
Blair Rollins was a student at Colorado High School.
How is he relevant to this case?
Blair Rollins' father, Jonathan Rollins, was convicted of first-degree murder. The Rollins family depended upon Mr. Brackman to represent Jonathan in court. Unfortunately, Jonathan Rollins was sentenced to life in prison. After the sentencing, Jonathan actually threatened Mr. Brackman. He yelled, "I'm going to get you back, Brackman, if it's the last thing I do."
Objection, hearsay.
Mr. Powell, there's a hearsay objection.
Your Honor, this is an exception to hearsay, pursuant to Rule 8033, a then existing mental state.
Ms. Humber,
Can you hear me?
I can, yes.
Your Honor, this is still a hearsay statement, as this is very much being offered for the truth of the matter asserted.
May I respond, Your Honor?
Yes, you may.
I agree. This is a hearsay statement. However, it is an exception to hearsay. Pursuant to Rules 8033, then existing mental, emotional, and physical condition.
I'm sorry, you were muddled there.
Oh, I apologize, Your Honor. 8033 states that then existing mental, emotional, or physical condition, which is a statement of the declarant's motive. This goes to prove motive, Your Honor.
Okay, well, I think that this could be construed as hearsay, as Ms. Humber objects, and it could come in within the exception to a hearsay exclusion as stated by Mr. Powell. I think on the other hand, an expert witness is able to testify to materials of which he does not have personal knowledge or which would otherwise be excludable under the rules of evidence. So since this man is testifying as an expert, I think that the objection must be overruled. So go ahead.
Professor Van Owen, what did Jonathan Rollins say to Mr. Brackman?
Jonathan Rollins said, "I'm going to get you back, Brackman, if it's the last thing I do."
Do you believe Blair Rollins at that trial?
Blair Rollins was there, which is very important, as it shows that he could have had a motive because of this. Look, Mr. Powell, Blair Rollins' father was ripped away from him and sentenced to life in prison. This can leave trauma on a child.
Professor, what other evidence did you find about Blair Rollins?
Blair Rollins was missing from school on the day of the murder with no alibi. If Blair were to blame Mr. Brackman for his father's sentencing, and this would give him the perfect opportunity to kill Mr. Brackman.
Professor, now that we know who Blair Rollins is, how is Detective Markowitz's lack of investigation on Blair Rollins example of confirmation bias?
When you look at Detective Markowitz's investigation, she develops her suspect based on a motive, based on their house being in the cell tower arc, based on them not being at school on the day of the murder, and because they made a threat. Detective Markowitz tried to take all of these facts and force them into her investigation, into her conclusion. Here's the thing. Blair Rollins fits under all of these circumstances, yet Detective Markowitz did not investigate them at all. This is clearly a failed investigation, and this is clearly confirmation bias.
Thank you, Professor. Your Honor, I have no further questions at this time.
All right, thank you. Ms. Humber, do you have cross-examination?
Yes, Your Honor.
Go ahead.
Thank you, Your Honor. Hello, Mr. Van Owen. I'd like to talk about and clarify something that you said on cross. You formerly worked at the police department.
That's correct.
In the mere 9 months you worked for the PD, you were sued by a woman for assault.
Yes, I can't speak about the details of this. However, yes, from police-approved practices.
And right after this assault suit, you left the PD entirely?
Yes, again, I did not agree with police-approved practices, as the way they are constructed led to me injuring this woman.
You left the PD after this assault suit? Is that a yes?
Yes, yes.
And today, you are testifying against police officers.
Look, the police whole system, there are problems. There's no doubt about that. There have to be people in this world who can figure out those problems and make sure that justice is being served. That is my goal.
Mr. Van Owen, let me clarify my question. Today, you are testifying against Detective Markowitz and Kyle Kuzak, who are police officers, correct?
Yes, that is my job, yes.
You left the police department with a chip on your shoulder, and now you testify against police officers.
Look, what you're trying to say is that there's a bias. And yes, there is. Of course. Look, the police, there are problems in the system, and I'm here to fish them out. It's trying to find justice. I'm not going to go out of my way and try to find incorrect evidence to find justice. I'm going to use fair evidence.
Thank you, Mr. Van Owen. I'd like to transition to your career as an investigator, specifically regards to payment. You charge $225 per hour for investigation work.
That's correct.
You charge $450 per hour for court testimony.
That's correct. And I'm paid for my investigation, not my testimony.
Your payment doubles just by stepping in a courtroom.
Once again, I'm paid for my investigations and not my testimony.
Okay, so you paid doubles just by stepping in a courtroom.
Yes.
Is that because in a courtroom you are under penalty of perjury?
Yes.
Let's talk more about the actual work you're getting paid for. You've consulted for over 100 cases?
That's correct.
Okay, and on estimate, how many of those have been for the defense?
All of them have been for the defense, as I mentioned earlier. The police have who only testify for the police, similar to how the defense have people who only testify for the defense. That would be me.
Okay, thank you. So this means you've never testified against the defendant.
Yes, once again.
Out of 100 cases, you have always been on the defendant's side.
Similar to how the police have people who have always been on the police side. Yes.
With that, let's talk about the facts at hand. You disagree with the prosecution's theory that there was a struggle during the crime?
Yes, I do.
You believe that ring alerts and scuff marks are unreliable indicators of a brawl?
Yes.
Now, you are the defense's expert in analyzing police evidence, correct?
That's correct.
And you heard both experts on the prosecution testify to a broken plate on the scene?
That's correct.
And yet, this broken plate is left entirely out of your analysis.
It's not my concern about the broken plate. My concern is that the police didn't investigate any other possibilities. For example, a preconceived notion to kill Mr. Brackman.
That wasn't quite my question. Is the broken plate in your report today, yes or no?
Yeah, no, it's not. Sorry.
Thank you, Mr. Van Owen. I'd like to transition to a different aspect of your story, specifically the alibi. It is your belief that Taylor and the defendant were together during the time of the murder,
Yes, that is correct.
that they were out looking for the defendant's phone?
Yes.
You believe that Taylor was sending texts to the missing phone?
No, I believe that, yeah, well, according to Taylor, yes. I believe that they tried calling the phone 5 times, yes.
And cell tower records of Taylor Perkins' phone could prove this theory?
They could. And if Detective Markowitz actually looked at the cell tower data of Taylor Perkins' phone, they could, yes.
That wasn't quite, it can prove, okay, thank you. In fact, you believe this evidence could prove the defendant's alibi?
Yes, it could.
You had the ability to obtain these records of Taylor Perkins' phone?
No, I didn't. The police, my investigation was based off all of the police's evidence. I don't have the ability to get into the cell tower data and figure out where Taylor Perkins' phone was. No.
Is that your testimony today here in court?
Yes, it is.
You did not have the ability to obtain these records of Taylor's phone?
Like I said, the police, I got all of my evidence from the police in their investigation. My job here today was to review the police's work.
Okay, and you suggested Taylor Perkins' phone records as possible proof of an alibi?
That's correct, yes.
And these records aren't here?
No, because the police did not investigate and get these records.
The proof of the defendant's supposed alibi is not here.
They are here. Taylor Perkins is proof of the defendant's alibi.
The cell tower records of Taylor Perkins' phone are not here.
No, because the police did not obtain them. It would be
Thank you,
nice if they did. It would be an easy case.
Thank you, Mr. Van Owen. While we're on the topic, let's talk more about cell tower records you did decide to look at. Could I direct your attention to Exhibit 16 and have
Sure thing.
my technician put Exhibit 16 up on the screen?
Yes, my apologies. One moment, it'll be right up.
No worries. And Mr. Van Owen, if you have a copy in front of you that you'd like to refer to,
Sure thing.
I would invite you to. Thank you, Ms. Spurlock. Okay, Mr. Van Owen, now you stated that these records are inconclusive of the records of the defendant's phone's location.
That's correct.
You claim that cell phones jump from tower to tower?
They do. Cell phones do not always go to the nearest tower. They go to the tower with the strongest signal.
Okay. If you could confirm with a yes after each statement, I'm just going to read the time and location of each record on this map, 5 in total.
Objection, Your Honor, cumulative.
Permission to respond, Your Honor?
Your Honor, you're muted.
You're right. Sorry. Go ahead.
Your Honor, I'm offering this evidence to specifically point out the times on the map.
May I respond, Your Honor?
This is not cumulative evidence.
Go ahead, Mr. Powell.
Your Honor, I think it was Miss Markowitz already pointed this out, and it's already been published to the jury, Your Honor. Reading this out is cumulative.
Well, I think that cross-examiners have the opportunity to refine the jury's attention towards aspects of an exhibit that they think are important. And therefore, I will overrule the objection and allow the testimony. Go ahead.
Thank you, Your Honor. 1247, cell tower near the defendant's house.
Yes.
1255, cell tower near a major intersection.
Yes.
105, 106, 117, cell tower near the victim's house.
Yes.
Were those all in chronological order according to time?
Yes, and the first ping was also near Blair Rollins' house.
And you believe this chronology is due to coincidence alone?
Sorry about that. Yes.
Thank you, Mr. Fano. And Your Honor, no further questions at this time.
All right, thank you. Ms. Powell, do you have any redirect within the scope of the cross?
Yes, Your Honor.
Go ahead.
Mr. Van Owen, let's talk about that alleged bias you have against police. Does that bias ever impact your opinions?
As I said earlier, I will never go out of my way to try to find evidence that would go against the police. I only look at their investigation and point out what's wrong with their investigation. So no, I would never use my bias against them.
Why have you only testified for the defense?
Because, like I said, when I was with the police, I felt that their practices were not achieving the means of criminal justice, and they needed reform. Therefore, I now only testify for the defense so I could see that change happen.
Has anybody contacted you to testify for the police?
No, they haven't.
Have they ever?
No.
Let's talk about how much you're being paid. Mr. Van, does the amount you're being paid today impact anything other than your bank account?
No, not at all.
And let's talk about your opinion about the struggle. Why is the evidence of the struggle insufficient?
The evidence of the struggle is insufficient, as these things could have happened in any sort of other way. For example, the broken plate, that doesn't always indicate a struggle. That broken plate could have been there before the whole intruder thing. So yes.
What about the scuff marks?
The scuff marks, a huge example here. Scuff marks could have been created 5 years ago. There's no way to date the scuff marks. Therefore, it does not indicate a struggle.
Let's talk about the cell tower. Are you able to get a court order to search cell tower records?
No, I do not work for the police, so I'm not able to get that. If we wanted cell tower data from Taylor Perkins' phone, that would all have to go through the police.
In your opinion, did the police have an adequate investigation?
No, not at all. This was clearly a failed investigation.
Thank you, Professor. Your Honor, I have no further questions.
All right, thank you. Ms. Humber, do you have any recross within the scope of the redirect?
No, Your Honor.
All right, thank you. Then the witness is excused. All right, thank you. The defense may call her next witness.
Yes, Your Honor, we call Avery Becker to the stand.
Ms. Becker, I remind you remain under the oath you took at the beginning of these proceedings. Ms. Vera, go ahead.
Good morning, Ms. Becker. My name is Ashlyn Bierrick. Please introduce yourself to the jury.
Hi, I am Avery Becker. That's Beckeer.
Let's start by talking about your relationship with Coach Brackman. How did you meet him?
I've done mock trials since I was a freshman, and he was the mock trial for the A team. So I would say it was probably when I tried out my freshman year.
Was he ever your coach?
Yeah, when I actually made the A team my senior year, and he was my coach then.
How do you feel about his coaching?
I think we're just very different. I'm more of a natural kind of go with the flow type of person, and he's very scripted.
How did this affect your relationship?
It was hard. He just was really hard on me because of how different we were, and he just never really appreciated me.
Now, we've heard a lot about different situations that strained your relationship. Let's hear your side of the story. When you were demoted to B team, how did you react?
I was upset, but for a bit, I just kind of hung out, did my thing, and Taylor actually ended up quitting the A team so I could be reinstated, which, Taylor's one of the real ones.
How did the regional tournament go for you?
It actually went really well. I won the best attorney award and the best closer. I finally felt like I had really solidified my spot on the A team and really proven myself, but coach thought otherwise.
What do you mean by that?
When he was debriefing us after the regional tournament, he just started getting on me. He was saying that I only won the awards because of luck and my good looks.
How did you react to all of this?
I completely regret it, but I took a marker, which I thought it was a dry erase marker, and it turned out to be a Sharpie, and I wrote worst attorney award, and I completely regret it. It was completely inappropriate, and it was just not me.
How did you apologize to Coach Brackman?
Well, first I tried texting him, telling him that I was happy to.
Your Honor, hearsay.
Your Honor, you're muted. Sorry.
There's a hearsay objection, Ms. Vera.
Can I ask to what section she is objecting to hearsay?
Ms. Senishin, what is the nature of the hearsay?
This witness cannot testify as to what she texted Mr. Brockman.
Why not?
It's hearsay because it is an out-of-court statement offered to prove the truth of the matter asserted.
Is it not her statement?
It is her statement, but
Is she not a party?
Could you repeat that, Your Honor? I'm so sorry.
Is it not a party? She's a party, isn't she?
Yes, Your Honor.
So it's not hearsay. Overruled. Go ahead.
Thank you, Your Honor. I'll repeat that question. How did you try to apologize to Coach Brackman?
First, I tried texting him, saying I was happy to scrub his car, trying to get the marker off, or I was happy to get a job over the summer to pay to have it repainted, but he never responded. And then I actually tried going to his work to talk to him there, but he wouldn't see me, and then he passed away, so I never got to say sorry.
That must have been hard on you. We can move on. We've heard a lot about your cell phone today. Let's talk more about that. You should have access to Exhibit 14. Please look back at this.
I do.
Do you know what these are?
These are the text messages that the prosecution's claiming I sent, but I've never seen these before in my life till this trial.
Send these text messages?
What did you say? You cut out.
Did you send these text messages, Ms. Becker?
No. Plus, it says I sent. Plus, Alex Fuentes is claiming I sent them to her. Me and Alex never got along. If I needed someone's help, I'd go to Taylor.
Is there any other way that you know for sure these texts weren't sent by you?
Well, my phone was gone. Like it was completely impossible for me to send them. I still don't know where my phone is. I actually had to buy a new one.
Where's the last place you'd seen your phone?
It was at the Fry Shack. Me and Taylor were playing video games, and I needed to use the restroom, and I think I must have left it on a table or something.
Who else was at the Fry Shack?
The mock trial team, they kind of they showed up while me and Taylor were hanging out there, and I remember seeing Alex Fuentes.
When did you realize that you lost your phone?
It was the next day. Me and Taylor were carpooling to school, and Taylor was like, "Why aren't you texting me?" And I was like, "What are you talking about?" And I actually realized that I had lost it, and we actually skipped school that day to go to the mall to look for it.
Shifting gears, let's talk about Alex Fuentes and Blair Rollins. Were you friends with Alex Fuentes?
No, we were like, she thought we were competitors, and she wanted my positions, and she constantly wanted the awards that I obtained. It just.
Objection, Your Honor. Hearsay. Or speculation. I'm sorry, Your Honor.
Response, Your Honor.
Eric?
Yes. The witness is clearly testifying to.
I'm sorry, your microphone is unclear.
Sorry, I'll come closer, Your Honor. This witness is testifying to a relationship between herself and Ms. Fuentes, so she clearly has knowledge of what went on between each other and the mutual feelings.
How does she get to testify as to what her competitor said to her?
I believe she did not say anything that was specifically said by by Ms. Fuentes, but again, she's testifying to the relationship that she was a part of, so this would not be speculation.
Then, Ms. Senishin, what's the nature of the objection?
I stand by my objection of speculation because this witness said that she thinks Avery wanted the award, or Alex, excuse me. She thinks her teammate, Alex, wanted the awards that she was winning. She cannot testify to someone else's thoughts. And the witness seems to have made it clear that she and Alex never really had a conversation about this, so she has no personal knowledge of Alex Fuentes' thoughts.
Ms. Varick, do you need to lay some foundation as to how the witness, Ms. Becker, came to this opinion or observation?
I can, Your Honor, if need be. But
I'm sorry?
I can, Your Honor, if it is needed, but also the witness did say, I think that Alex Fuentes thought this way. She is not exactly saying this is what Alex Fuentes thought.
Okay, why don't you lay some more foundation? Perhaps we could understand this better.
What was the relationship you had with Ms. Fuentes?
Well, we were on the mock trial team together. We were on the A team together, to be exact. And as I said before, we were kind of competitors, I guess. I wouldn't trust her for anything. I would really lean on Taylor. He was my best friend, especially on the team.
Would you ever go to Ms. Fuentes for help?
No, I would go to Taylor. Easy.
Now, do you know who Blair Rollins is?
Not exactly. Like, I've definitely I know who he is, but I don't really know him. I know him and Alex are friends, and that his dad was represented by Coach in trial and he was convicted of first-degree murder. That's it.
Now, Ms. Fuentes, we've heard many different things been said by you throughout this trial. I'm going to ask you the one question that everyone wants to know. Did you kill Coach Brackman?
No. No. I couldn't kill anyone.
And why should we believe you?
I know me and Coach didn't get along, especially after his car, but to go to his house, to break in, to stab him? No, that's not me.
Thank you, Ms. Fuentes. And with that, I'm done with your.
All right, thank you. Timekeepers, we have one that says 45 seconds left in this segment. Does the prosecution timekeeper agree with that?
Yes, Your Honor, we have the same time.
Okay, thank you. Ms. Seneschal, do you have cross-examination?
Yes, Your Honor.
Go ahead.
Good afternoon, Ms. Becker.
Good afternoon.
You said that mock trial came naturally to you, right?
Yes, I did. I loved it.
But despite your talent, Brackman always criticized your work, didn't he?
Yeah, he never appreciated me.
And after Brackman demoted you to B team, you said that you did everything you could to convince Brackman to put you back on the A team.
I did.
And that's because mock trial meant everything to you, right?
I love it. I want to do this forever.
And like you said, you won the Best Attorney Award at regionals, right?
I did, actually, yeah. And the best closer.
That's awesome.
Thank you.
Despite those awards, Brackman continued to criticize your work, didn't he?
Yeah, he did.
And this made you really angry, right?
Yeah.
In fact, you called him the worst coach in the state.
Which was so stupid, but I did.
And you were so angry that you stormed out of practice?
He was just belittling me. I had to go. I did.
And then you took a permanent marker and wrote in giant letters across the hood of his Porsche, Worst Attorney Award, right?
It's the biggest mistake of my life, and I regret it so much, and I did. And I tried to make it better, but...
So the fact is that you damaged Mackenzie Brackman's private property.
I didn't mean to. I thought it was a dry erase marker, and I tried.
Yes.
I did as much as I could.
And Mackenzie Brackman did not press charges, right?
And I'm so grateful for it. I owe him.
But Miss Becker, that's because he was murdered before he could press charges against you, wasn't it?
I don't think so. He definitely could have, at least the next day, but he didn't, and I owe him, and I am so grateful.
After you vandalized Brackman's car, he kicked you off the mock trial team, right?
I completely deserved it. He did.
And you said that made you even angrier, right?
Don't think I phrased it that. I believe I used matter, but...
In your statement, you said that being kicked off the mock trial team made you even angrier, right?
I said matter, but yes.
And you spoke to your mom about this incident, right?
I did. I told her that I got kicked off the team eventually.
And you even told her that you would get back at Mackenzie Brackman if it was the last thing you did. Is that right?
It's so petty, especially everything that's happened. And I stupidly did, and I completely regret it. And I should not have. It was inappropriate.
So, Ms. Becker, let me just get this straight. You made this statement And then Mackenzie Brockman was found dead. Is that right?
I don't believe that they were that close together. I did make that statement, but I don't believe that he was just found dead.
Ms. Becker. And you heard Ms. Cifuentes testify today, right?
I did.
And today Ms. Cifuentes testified that you texted her, "I'm gonna wait until he's, Brockman, at work, then break in and trash the house." You heard that, right, Ms. Becker?
I heard that she said that, but I didn't send any of that. I didn't say that.
Right, you deny sending these texts, right?
I do. I did not send them. I couldn't send them. It was impossible.
And that's because you allegedly lost your phone on the day of the murder. Is that right?
I did, and I had to buy a new one. I spent the day looking for it.
Miss Becker, you were not at school on the day of the murder, were you?
No, I was with Taylor at the
No
mall.
further questions, Your Honor. Thank you, Miss Becker.
All right, thank you. Is there any time left for the prosecution for recross?
No, Your Honor, no time remains.
Okay. Ms. Varick, do you have any redirect within the scope of the cross?
Yes.
You have 45 seconds.
Why did you make that statement to your mother that was brought up in cross?
I was just so upset. I was just so sad, and I didn't realize what I had done, and it's so stupid, and I just regret it, and I wish I could take it back.
Was there any meaning behind it?
No, of course not.
Lastly, where were you on the day of the murder?
I was at the mall, but security cams could confirm it.
And who were you with?
Taylor.
No further questions, Your Honor.
All right, thank you. The witness is excused. Does the defense have any further witnesses?
No, Your Honor, the defense rests our case.
All right, thank you. We're good, Brenda? Okay. Are the parties ready for closing?
Yes, Your Honor.
Yes, Your Honor.
All right. Prosecution.
May I proceed?
Yes, you may.
Mischief was intended. In murder, it ended. Members of the jury, allow me to take you back to a scene that my co-counsel, Miss May, mentioned in her opening. It's 3 o'clock on a Thursday, and Avery Becker furiously storms into the kitchen. See, practice after practice, her mock trial coach has ridiculed her efforts. Coach Brackman's criticism have gotten worse, and she's had enough. After Coach Brackman demoted and removed the defendant from the team, she boiled and raged, climbed to the top of his car, and wrote in bold permanent marker across the hood, "Worst Attorney Award." But to her, this wasn't enough. As she hides away the Sharpie, the defendant texts her friend Alex, telling her plan to break into Brackman's house and once again vandalize his belongings. Her eyes are tearful with anger. The defendant's mom enters the kitchen to ask what's wrong, to which the defendant responds, "I'll get back at him if it's the last thing I do." Today, the prosecution has proved beyond a reasonable doubt that the defendant committed second-degree burglary and first-degree murder. We have proven that the defendant knowingly and unlawfully entered the dwelling of Mackenzie Brackman with intent to commit criminal mischief. While in this dwelling, the evidence proves that the defendant, during a burglary, caused the death of Mackenzie Brackman. To break that down, mischief was intended, in murder it ended. The prosecution holds the burden of proving the defendant guilty beyond a reasonable doubt. Please remember that reasonable doubt is not based on possible or speculative doubt. Reasonable doubt must be based on the cumulative evidence presented. Looking at this case as a whole, the prosecution has left no reasonable doubts. The defendant demonstrated intent to break into Mackenzie Brackman's home. Alex Cifuentes read the vengeful texts
wherein the defendant states, "I'm going to wait until he's at work, then break in and trash his house." That'll show him. Less than 24 hours later, a person masked and gloved with the same height and build as the defendant is seen at Brackman's house. Detective Kyle Kuzak presented video evidence of this intruder as she is seen breaking in through the back door, just as the defendant said she would. Upon entering, the defendant came face to face with Mackenzie Brackman. A confrontation ensued. Brackman was stabbed, and the defendant fled the scene. Detective Jordan Markowitz testified to evidence of this struggle firsthand: a broken plate, a flipped chair, and Mackenzie Brackman dead on the floor from a fatal stab wound. During this time, Miss Cifuentes sat in class, Avery's empty seat beside her, and wondered why she wasn't in school that day. But members of the jury, you know where she was. Detective Markowitz testified to cell tower records, placing the defendant's phone at Mackenzie Brackman's house at the day and time of the murder. She drew a clear line of the path. I challenge opposing counsel to answer the question, where is the defense's line? What is the common thread? The prosecution has proven the answer to be quite simple. They don't have one. Today, we look back at Avery Becker in the kitchen, fired up after vandalizing her coach's car, planning her next move. This time, her attack is more permanent than a Sharpie. Mischief was intended, in murder it ended. Members of the jury, the defendant, while unlawfully entering Mackenzie Brackman's home, caused the death of Mackenzie Brackman. Find her guilty.
All right, thank you. What time is left for rebuttal if she chooses to use it?
52 seconds, Your Honor.
52?
That is correct.
All right, thank you. Ms. Proctor, when you're ready.
Yes, Your Honor. Justice doesn't come in a puzzle box with a picture on top. It's March 6th. Detective Markowitz gets to Coach Brackman's house, and she immediately starts trying to put pieces of the puzzle together. A dead body, a bloody knife, some ring video footage. But what she doesn't have is any fingerprints, or any DNA, or any suspects. So like a child who's missing some of the pieces, Detective Markowitz begins trying to force the pieces together. Once she talked to one student of Coach Brackman's, Detective Markowitz zeroes in on Avery Becker. She ignores several critical puzzle pieces along the way: a credible alibi, a scheming witness, and an alternate suspect. A suspect was intended, and a rushed and incompetent investigation, it ended. Your Honor, counsel, members of the jury, my name is Madeline Proctor, and along with Ashlyn Vierick and Chalmers Powell, we had the privilege of representing Miss Avery Becker, a flawed but innocent young woman. She had the right to remain silent, but instead, she chose to tell you what really happened. She was with her friend on the day of the murder, and she doesn't know where her phone is. You should believe her because you focused on the three things: a screenshot, cell towers, and a stronger suspect. A screenshot. Can't trust it. The prosecution wants you to believe that Miss Becker sent those text messages. But really? Alex Cifuentes is the one that sent those text messages to the detective. You remember her. She's the one who does twice the work and gets none of the credit. She's the one who waited a full day to send that screenshot. And she's the one who conveniently forgot her phone the night of the interview. She faked those text messages. What's more, the prosecution told you in this courtroom that they were not offering those text messages for the truth of the matter asserted. They have no evidence of the intent to commit criminal mischief. What's most important, though, members of the jury, is that you cannot trust this screenshot because Detective Markowitz did not do his job, her job. She was entered as an expert in cell phone analysis, but the only cell phone she downloaded in this case was the victim's. She never downloaded Mr. Perkins. She never downloaded Ms. Cifuentes's. She did nothing to verify those text messages were even real. Miss Humber got up and tried to tell you that Professor Van Owen was the one who was supposed to download those phones. He physically could not. It was Detective Markowitz's job, and he failed. Cell towers. The cell towers are just dangerous enough to accuse Miss Becker, but they don't act as a GPS. Miss Becker didn't even have her phone. The phone can ping wherever it wants to. Miss Becker didn't have it. Stronger suspect. The prosecution wants you to believe that person in the Halloween mask and the black hoodie and the gloves was Miss Becker. In reality, members of the jury, the person in that video was a stronger suspect, a suspect that fit the puzzle perfectly. Blair Rollins. Blair Rollins is the suspect who blames Coach Brackman for his father being put in jail for life. Ask yourself, what's a stronger motive? A high school extracurricular or losing your father to prison? Blair Rollins was the one who lives in the exact same cell tower arc as Miss Becker. Blair Rollins was missing then, and he is still missing now. The detective never talked to him. In just a moment, my opposing counsel will get up here and try to explain away all of this. Don't let her. Ask her this question and make her answer it. If Detective Markowitz was really an expert in forensic data recovery, why didn't she download the screenshots? Why didn't she download Miss Cifuentes's phone? Why didn't she download Miss Perkins' phone? Members of the jury, this case is a tragedy. Don't make it two tragedies by convicting an innocent young woman. The prosecution had the burden of proof beyond a reasonable doubt. They failed. They had to prove to you that it was Miss Becker. And the screenshot, the cell towers, the stronger suspects, each is reasonable doubt. Find Miss Becker not guilty. Thank you.
All right, thank you. Ms. Humber, you have 52 seconds if you choose to use them.
Yes, Your Honor. Permission to proceed?
Go ahead.
The defense has answered the question I left you with. Their theory has no common thread. The defense sees evidence exactly as Ms. Viereck said, a puzzle without form. They don't want you to see what the full picture reveals, yet the jury instructions implore you to observe all the evidence as a whole. They talk about Blair Rollins having it on the scene, yet don't prove any sort of motive. They talk about Detective Markowitz not providing evidence when when Detective Markowitz is required to show the evidence relevant to today's case. Mischief was intended and murder ended. Thank you.
All right, thank you. With that, the case will stand submitted. The scoring judges were now going to do what they need to do, and people can stand down while they do the math. Do we have a courtroom monitor here?
Yes.
Who is that?
Right here, Jacob Barson.
Jacob, do you have, I haven't been told how your part of this is going to work. So do you have that under control?
Sure. I will just be confirming that the coordinators will get the score sheets, and then I'll end the call once we have that confirmation.
All right, thank you.
No problem.
I'm done.
That was pretty fast. Very good. So are the sheets being submitted? Are we?
Yes.
All right, we're in good shape. I think we can take a couple of minutes for each of the scoring panelists to give some feedback if they so choose.
I'll go first.
Go ahead. We have 2 minutes each.
All right. Guys, I think you did a great job. Everybody here, you can tell, has thoroughly prepared for this, and that's awesome. One thing that we all kind of learned this year is being able to change gears and switch and do things quickly. It's definitely new for the courts for us to be having hearings and trials online. And it's probably a whole new thing for all of you, especially if you're new to mock trial, to get used to something like this. So seasoned attorneys have a really hard time with it, and all of you guys did just fantastic. My only piece of advice for all of you is just be careful on relying on your notes too much. Have confidence. You guys all know this case. It's very, very clear that all of you know your facts very well. So, have confidence and have fun with it. This is why you guys are a part of this, is to have fun. So, don't get too caught up in it. Other than that, I have no other real critiques for you all. I wish you all the best of luck.
All right, thank you. Nick, have any comments?
I'm not kidding when I say this. You guys really should take advantage of going to the Arapahoe County Courthouse and sitting in court when we're back in person, or jumping on WebEx and watching. You guys will be very, very surprised at how you guys are much better than than a lot of people that I work with in court every single day. And I'm not just saying that. You guys have very good knowledge of the rules of evidence. You guys present yourselves in professional ways, and you guys have a good way of communicating and advocating for your respective clients. And for the witnesses, you guys had to have really detailed understanding of the facts and of your witness statements as well. So you guys just did outstanding. And I'm not just saying that. I really hope you guys do get a chance to go and watch court, because you guys are doing a lot better than some of the people we call colleagues. Criticism is hard to give you guys. Always breathe and always go slow. That's the only thing. It's easy to get whipped up. You get in the mode of trial work, and you're thinking about your memorized pieces. Just breathe and go slow. But I thought the 704 objections on Markowitz was excellent, and I liked the interchange there. The objections are the most fun because you guys are thinking on your feet. You're off script. Same with the foundation objection on Exhibit 14 with Cifuentes. That was just really fun to watch. I think both sides and the witnesses handled that really, really well. Congrats, guys. Good luck in your next rounds. You did awesome.
Thank you. Brenda?
I basically the same type of things. I was really impressed. All of y'all speak very, very well, and you enunciate, and you have passion, and you really impressed me with it. And like the witnesses were great. Avery almost made me cry. So I thought you were all very, very professional. And I would have that one comment about maybe slowing down a little bit, and just believing that you know everything. Oops, I'm sorry. I just knocked something over. But I thought it was excellent. I really enjoyed it and got a lot of information. I was judged a couple of other mock trials last week, and it's so interesting because every group brings out something different in this case. So I was really pleased in the way you presented it, and I liked your openings and your titles for your cases. That was fantastic. So good job, everybody, and good luck.
All right, thank you. I guess I would just add, I've been doing this judging for about 10 years in mock trial, and the first round of the regionals is often like, I don't know what I'm going to get. You guys put on a really, really good show, and I just was very, very impressed with all of you. I thought the lawyers were very prepared and thoughtful. I thought the witnesses were very entertaining and played their parts very well. So I think that you guys have a good future going forward in this tournament. I wish you luck, and don't kill your coach. Thank you. I think that's us.
Thanks,
Thank
everyone. Scorecards have been submitted, and your teachers or coaches will be notified of what room you'll be in for the next round. Great job, everyone.
Thank you.
Thank you. Good job, Team G.